All right. Jefferson County Court at Law number 2 is back in session. The court is in session with 3 dockets on today's date, May 4th, 2026. We have an announcement docket, pretrial conference docket, and a trial docket. When I call your name, please come before the court by yourself. Well, come before the court with your attorney. If your attorney is not here, we'll wait for your attorney to arrive. If you're representing yourself or if you do not have an attorney representing you, please come before the bench by yourself when I call your name. First case is cause number 25-CCCR-2774. Case is style of state of Texas versus Joseph Ryan Martin. Mr. Martin is on Zoom. And Mr. Martin, you can take your mic off of mute.
Yes, sir.
How are you doing, Mr. Martin?
Busy working, trying to stay busy.
I understand that. Now, Mr. Martin, you're represented in your case by your attorney, Attorney James Paget, who is present here in court.
Yes, sir.
And Mr. Paget, how are you doing?
I'm doing well. Good morning, Your Honor.
Good morning. The state is represented in this case by Attorney Cornelius Williams. And Mr. Williams, how are you doing?
Very well, thank you, Your Honor. How are you and your staff?
We're doing fine. Thanks for asking.
You're welcome.
Now, Mr. Paget, what is your announcement in Mr. Martin's case?
Your Honor,
Hold on. I don't know why that came on. Is it right there?
Okay. So I didn't think it was my client.
No, that says adjourn with audio. No, it's not audio. It's not on, it's off. Maybe somebody else had it on. Okay.
Okay, Your Honor, this is my first appearance. I've received all the discovery on this case. We have a Hardin County situation, also a misdemeanor coming up within the next week or so. I have an offer from the prosecutor now. All I need to do is make the appearance in Hardin County. We want to try to run something concurrent. So we're making good progress on the case. I'm working with this gentleman here, and he's been very quick to get me an offer. So we're moving forward quickly on the case.
So, do you know what?
I do not know the date on the Hardin County case right now. You know what? They emailed me. I don't want to hold the court up, but I want to say it's coming up. I just don't have my schedule with me.
That is June. So June 3rd.
Okay, hold on.
Mm.
Excellent. Thanks. Somebody's. Okay, everybody that's on Zoom, make sure your mic's on mute. You don't see it?
I really thought I had it, Your Honor, honestly,
Okay.
but I don't. What I'm trying to tell the court is we're making speedy progress.
I understand.
We'll have an announcement within 30 days
Okay.
on this case.
Okay,
I just want to run it concurrent with the Hardin County
Okay.
situation.
give us a,
Thought I had it.
Glenda, just give us a reset date.
June 3rd.
Is June 3rd fine?
That's fine.
That's fine with the defense, Your Honor.
Okay,
It's,
so, Mr.
equal to the state.
Mr. Martin, your case will be reset till June 3rd, 2026.
Yes, sir.
On that day, you need to be in court in person. Stay in contact with your attorney and your bondsman. You're free to go. Again, the
Yes,
court
sir.
date is June 3rd, 2026 at 9 a.m. And you have a blessed day.
Thank you, Your Honor.
You're welcome.
also have
Eddie Renfro? Eddie Renfro?
I apologize, I really thought I had that email.
Mr. Renfro, you can put your hat on right there. How are you doing, Mr. Renfro?
Fine, so you want?
I'm doing fine, thanks for asking, Ms. Renfro. You're represented by your attorney, Attorney James Paget. And let's see, Mr. Paget, I think this is your first court appearance, is that
It
correct?
is, Your Honor. Again, we're making good progress on this case. It's Mr. Vernon's case. I'm going to email him to request an offer today. I've
Okay.
received all the discovery. I'm
Oh,
going
you
to
have?
review it this week and then I'll review it with my client.
Okay.
We'll make an announcement when we come back.
Would you like this on the same date of the first case?
Absolutely.
Okay.
Pleases the court.
So this case will be reset to June 3rd, 2026 at 9 a.m. Mr. Renfro, you can get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. And Mr. Paget, do you have any more cases?
I do not, Your Honor. May I be
Yes,
excused?
you're free to go and you have a blessed day.
Thank
as
you,
well.
Mr. Williams.
What do you want?
Well, that's one of the good one, I'll write it down, so I'll have to send it on file.
Let's see.
I don't need 2 copies.
Okay. What is? That's a catch.
It's too good for me.
Yes, catch.
You go test, no, it's, don't test, no.
Ms. Carlton, you have a case on the, I don't see your name on the document.
It's as of Friday, but I guess y'all remove, y'all
I
recess.
think, you made an announcement, at least we was understanding that you weren't gonna be here.
Leave Tuesday. So
Oh.
Tuesday's when I'm going.
Yes, we had the dates wrong.
I think he can even appear via Zoom. So.
Yeah, I'm sure I filed it.
Yeah, I mean, it's not set today, so it was already reset, wasn't it?
Yeah.
You could give her the name of your client and she can check to see when when it was reset to.
David DeSombo and Raymond Green.
Okay, you're welcome.
I got an announcement. Not for you, right?
Okay, hold on. Okay, Grant. Dante Grant.
I'm doing well. How you doing?
This is cause number 25 CCCR 2894. It's on page 7 of the announcement document. The case is filed in the state of Texas versus Dante Grant. I'm gonna need some bond condition. Mr. Grant, your full name is Dante Grant.
Yes, sir.
How are you doing, Mr. Grant?
Okay.
You doing okay?
Yes, sir.
That's good. Mr. Grant, you're represented in your case by your attorney, Attorney Buddy Reynolds. And Mr. Reynolds, how are you doing?
Doing well, thank you, Judge.
Mr. Reynolds, what is your announcement in Mr. Grant's case?
I'm informed that Mr. Grant may have some pending cases yet to be filed. So I asked this case to be reset on the announcement docket and perhaps all of them will be taken care of at once.
Okay. Let's see, Officer Phil. How's that? Okay. Mr. Grant, I need to give you some bond conditions. Okay, and you'll get a copy of these bond conditions. Before you leave, okay? Do we have could you give us a court date, Mr. Grant? We're gonna reset this case.
June 1st.
Okay, this case will be reset to June 1st. I think is this your second court appearance? Mr. Grant, first,
Well, he had one, I think he was in custody.
okay. Let's see, well, you were appointed in February. Yeah. February. Yeah, he was in custody. He bonded out February 17th. Okay, here we go. Mr. Grant, I'm handing you attorney a copy of these bond conditions. He's going to hand those bond conditions to you. I'm getting ready to go over these bond conditions. And it states standard bond conditions in County Court at Law number 1, following return of a criminal information in County Court at Law number 2. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Okay.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? You have to speak up.
Yes, sir.
Okay? Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim. I think her name is Demaria Davis.
Yes, sir.
Of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the victim. Do you understand that condition? Condition number 4 does not apply. Condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond will be revoked, and once your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Oh, shoot.
Mr. Grant, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked or if issued for your arrest, you'll be arrested and placed in Jefferson County Jail. Do you understand?
Yes, sir.
Okay, now, Mr. Grant, your case is being reset till June 1st, 2026 at 9 a.m. On that day, you need to be here in court in person. You can get your reset. Once you get your reset, you're free to go. You have a blessed day.
I'm on the case.
Okay, and Mr. Reynolds, you're free to go as well. You have a blessed day. Let's see. Yes. Ms. Simmons, you hear Mr. Galmore's case?
Yes, Your Honor, there should be two. Mr. Fultz on the file docket on 50 years. We need to.
Okay. Stephen, what about Jael Gutierrez?
On that one, we need to hold, Your Honor, but we
Hold.
can make the announcement on Mr. Fultz.
Okay, hold on a minute. Okay, hold. On who? Let's see.
He's on the trial docket, Your Honor.
Oh, okay,
That's the-
Pault. Okay, he's
Yes,
number,
sir.
okay. William Kenneth Pault? Mr. Paults, how are you doing?
I'm good. How about yourself?
I'm doing fine. Thanks for asking, Mr. Paults. You're representing your case by your attorney, Dustin Galmore. However, Attorney Galmore is not here. Standing in for Attorney Galmore is Attorney Haley Simmons. Does Ms. Simmons have your permission to stand in for Mr. Galmore?
Yes, Your Honor.
Okay. And Attorney Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking. Now, Attorney Simmons, what is your announcement in Mr. Paults' case?
Ready?
Next state?
The state is ready, Your Honor, to
Okay.
point out that, this case has a preferential setting.
Right.
With that, Your Honor, the, remaining cases, I see no way which we will, resolve these matters. There are other cases that's also set on the jury's charge, respectfully, Your Honor. We have counsels from, outside the city. We
Okay, well-
got set those,
Well, we'll call those cases as they come up.
yes, Your Honor.
Okay. All right. Now, we'll see you at 1:30.
Thank you, Judge.
Okay. As Mr. Bill Bond. Kimler.
What? That person?
Kim. Okay, Bill Bond.
Unless I miscounted, I thought, the one with, Bailey was the third oldest, and I had Hadley as the second oldest. Tyrone. Hadley.
Yeah, no one. Yeah.
What Billy? What Billy?
Kiana Bailey with, wife. I had that as the
Oh,
third oldest.
Oh, okay, okay, yeah, okay.
And I had Tyrone Hadley.
Right. Yeah, there's both of those were right. Okay, let's see. Jansen Bailey. Mr. Jeffers. Troy Michael Ogle? Is that Ogle? Am I pronouncing it right? Ogle? How do you pronounce your last name? Ogle? Okay.
Yes, sir.
Okay, this is cause number 25 CCCR 2624. Case is style, the state of Texas versus Troy Michael Ogle. And Mr. Ogle, how are you doing?
Well, Your Honor, you.
I'm doing fine. Thanks for asking.
Yes, sir.
Now, Mr. Ogle, you're represented in your case by your attorney, Benjamin Jeffers. Attorney Jeffers, how are you doing?
Doing well, Your Honor. Thank you.
That's good. Let's see, Mr. Jeffers, what is your announcement in Mr. Ogle's case?
Your Honor, communicating with the state, believe we're on track for a resolution, hoping for one more setting to get that ironed.
Okay, let's
That's
see.
correct, Judge. We've had meaningful talks.
Okay, so I think you've been on this case since December. So we'll give a, how much time do y'all need? That's, this is gonna be the last.
So 30 days. It's official.
Okay, no, she's telling her something. Okay, this case is reset to June 3rd, 2026. I'll just put it as a plea docket. Okay, once you get your case reset, you're free to go. And you have a blessed day. And Mr. Jeffries, is this your only case?
That is.
You're free to go as well. You have a
Thank you.
blessed day. All right,
Good to see you.
okay. Next case is Dwight Edgar Anderson. And
Your
Mr.
Honor, this is
Anderson-
Scott Rennick. I'm his counsel. I
Okay,
believe
Mr.
Mr.
Anderson is appearing via Zoom.
Yes,
Mr.
Your Honor.
Anderson, how are you doing?
I'm doing fine, sir.
That's good. Mr. Anderson, you're represented by your attorney Scott Rennick.
Yes,
And
sir.
Mr. Rennick, how are you doing?
I'm great, Judge. How you doing, sir?
I'm doing fine. Thanks for asking. Now, Mr. Rennick, this is your first announcement in Mr. Anderson's case? Is that
Your
correct?
Honor, yes, and we were informed this weekend by the prosecutor that this case is going to be dismissed.
Yeah, I sent it to.
Yeah, it's on
Oh, okay. Okay, I have this dismissal before me now. Miss Farrah Nixon is representing the state. And Miss Nixon, how are you doing?
I'm fine. How are you, Your Honor?
I'm doing fine. Thanks for asking. And Miss Nixon, I have this dismissal.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
I'm signing the dismissal. Mr. Rennick, I just signed the dismissal in this case. And the court coordinator will be faxing you a copy of this dismissal.
Thank you, Judge.
You're welcome, and Mr. Anderson. Your
Yes,
case
sir.
has been dismissed. You're
Praise
free to
the Lord.
go, and you have a blessed day.
You
And
do
Mr.
the well.
Rennick, thank you. And Mr. Rennick, this is your only case?
It is, Your Honor.
Okay, you're free to go as well, and you have a blessed day.
You too, sir.
Thank you. Okay, I just did that. Okay.
But it's been so long.
Where? Oh, there he is. Next case is cause number 26CCCR 0418. Case is style of State of Texas versus Andre F. Illen. Mr. Illen is appearing via Zoom. And Mr. Illen, how are you doing?
I'm doing well, thank you. Yourself?
Oh, I'm doing fine. Thanks for asking. And Mr. Illen is represented in this case by his attorney, Attorney Larry Bailey. And Mr. Bailey, how are you doing?
Doing fine, Your Honor.
That's good. Now, Mr. Bailey, what is your announcement in Mr. Illen's case?
You had asked at our last setting for us to brief out the
Right,
appellate process on a
Right.
CDL trucker.
right.
I believe you're correct. There's no deferred that should be offered at the appeal level.
Okay,
And I will ask that this be reset so I can get with Cornelius
okay,
and try and get this taken care of.
okay.
We agree.
Give us a reset date.
Oh.
I think your client he lives out of town, right?
Yes, he's
Yeah.
a long way away.
Yeah, she said June 1st. Is that too soon, or
Let me-
does he need to make some arrangements?
Let me see. Could you make it here June 1st, Andre?
Yes.
Okay,
Okay, June 1st should be fine.
okay, so we'll reset it for June 1st at 9 a.m. And Mr. Illen, your attorney and your bondsman will be given notice of your reset date. Stay in contact with your attorney bondsman. And Mr. Bailey, your reset will be sent to you. You're free to go, Mr. Illen, and you're also free to go, Mr. Bailey, and both you and Mr. Illen have a blessed day.
Thank you, Your Honor. We appreciate that.
You're welcome.
Я ничего не понял, в чем смысл.
Она насчет чего?
Okay. Let's move those. Now, this is cause number 23 CCCR 2390. Case is style the state of Texas versus Cameron Taylor Smith. And Mr. Smith, is that your full name?
Yes, sir, Your Honor.
How are you doing, Mr. Smith?
Doing well. How are you?
I'm doing fine, thanks for asking. Now, Mr. Smith, you're represented in your case by your attorney Mark Faggart. And Mr. Faggart, how are you doing?
I'm good, Your Honor.
Okay, now, Mr. Faggart, what is your announcement in Mr. Smith's case?
He is signed up for the BIP program and he's doing that, Your Honor.
Okay, let me ask you this question. When did he sign up?
When did you sign up?
It would be 2 weeks ago now.
Oh, so you just signed up.
Yes, Your Honor.
So, good.
Yes.
He might be on, his name might be on that list. Hold on a minute. We got a list. Signed up back in 2025. I have a note here. Complete BIP program, June 18, 2025. To sign for BIP per attorney, September 30 to 2025. That was, yeah. So I was wondering when you signed up.
I recall there were some issues about him getting the letters of reference and things like that, and
Okay,
approach it, and there were some issues with the initial signing up.
okay,
And I had to get involved in trying to help him.
okay, okay. His name is Cameron Smith. And you can look under the attorney, Faggart.
Well, we just did a list with him.
Oh, that's pretrial diversion list.
See, that's all we got. I didn't get.
Oh, okay, so
I can.
what we're gonna do is, the DA's office is supposed to send us a list of people who get in the bill. They hadn't done that. So, we're gonna make a note, and so we're gonna contact their office as well.
Good.
But Mr. Williams, how long is the BRIP program? Well, this case is gonna be inactive anyway.
Roughly 6 months to a year.
Yeah, so the case, what normally happens, what,
I believe it was 18 weeks.
18 weeks? Yeah, and so what we'll do is, I think, MIS and the DA's office is working on it. They say they're gonna make the case inactive. Okay, they have to fix the system to allow them to do that in this type case. Okay, hadn't been done yet. So we're going to just give you a standard reset,
Okay.
but at some point it's gonna go inactive, and then I guess when it goes inactive, we'll send a notice to you,
That's great, Your Honor.
okay?
Your Honor, I had one other case on.
Hold on a minute. You can get your reset. Once you get, You say June 3rd?
I will be out of the country,
Okay,
Cabo, you know.
you have his vacation letter?
Yeah, I have one on file, but I'll send it to you too.
Please send it to me.
I will.
What date, so it's gonna have to be after
I don't
June,
know.
Yeah. I
you
got a
in
bunch-
June?
First week of June works. I'll get back on the 5th or 6th, the 8th. I think I have other stuff down here on the 8th.
Okay, on the 8th? What's the 8th? Okay,
Monday.
June 8th? Okay. So we'll reset it to June 8th, 2026, okay?
Thank you, Your Honor.
Okay, and you could get your reset. Once you get your reset, Mr. Smith, you're free to go. And Mr. Thaggart, I think you had another,
Thought I had another case on here, but.
I don't see it.
I know Ralph Kilmer's just substituted in.
Oh, okay,
Thank
okay.
you. My be excused.
Yes, you're free to
Thank
go.
you.
Rahil Ali, is he here?
Judge, he's still
He's
driving.
still, okay, that's
He
fine.
was on the Zoom and I told.
Oh, he was?
Well, I told him to
Okay.
get off and get up here.
Okay, okay, okay.
He lives in Houston, that's why I'm here. So he's like.
Oh. Next case is Brandon Galea. Okay. Cause number, it's on page 3 of the announcement docket at the bottom. Cause number 263, excuse me, 26 CCCR 0748. And this is the case is styled in the state of Texas versus Brandon, is it, last name is Galea or Galea?
It's Gallier.
How is it pronounced?
Yeah, I don't have them.
Oh, okay. Okay. And you said, how do you pronounce your last name?
Galley, Your Honor.
Galley?
Galley.
Galley.
Yes.
Galley, okay. Okay, how are you doing, Mr. Galley? Oh, I'm doing fine, thanks for asking. And you're represented in this case by Austin Hagee,
Austin's my boss. My name is Lucas Holzman.
Holzman,
HOLZMANN.
HOLZ,
MANN.
Holzman,
Yes, sir.
okay. How are you doing, Attorney Holzman?
I'm doing well. How are you?
I'm doing fine, thanks for asking. Now, before we get started, now, Mr. Galley, your attorney of record is Austin Hagee. He's not here today. Standing in for Attorney Hagee is Attorney Holzman. Does Attorney Holzman have your permission to stand in for Attorney Hagee?
Yes, sir.
Okay. Okay. Now, Attorney Holzman,
That's right.
what is your announcement in Mr. Galley's case?
Your Honor, this is our first setting. And this is a Class A misdemeanor assault
Yes.
And we are awaiting, Mr. Prosecutor Williams to get back to the complaining witness in the case, to see how he wants to proceed.
As well as, we have to tender the physical media in this case. Seemed that there was a, mistake, snafu, and it was not tendered to. So when I have the, moment, I will ensure that Mr. Holtzman, receives the, physical media within this case.
Okay, so he needs a complete discovery. State needs to talk to the witness, and then the state will provide the defense with an offer. Is that correct? After talking to the witness?
Oh, correct, Judge.
Okay. Okay, let me see. Let's see, discovery motion.
We've actually got.
Okay.
Information. That can be I need to give Mr. Galley some bond conditions. Our court coordinator is gonna make a copy, and then I'll go over these bond conditions with Mr. Galley. So December 28th. Hey, Mr. Galley, you look nice today.
Appreciate it.
Yeah, you're welcome. Kind of remind me of case we had last week. I think one of the lawyers, I think a lawyer asked the jury, actually asked the panel if when they walked in, did they wonder what his client did? And the jurors, the panel said, well, I thought they would have defended, pointed at the state.
I would have hit the floor.
Yeah, I guess the way they was dressed, Here you go. Okay, I'm going to go over these documents with you. And it states, standard bond conditions in County Court at Law number 2. It says following return of current information in County Court at Law number 2 of Jefferson County, Texas, all bill bonds executed for release any defendant or named order subject to the additional condition. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, Your Honor.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim, Canyon Sullivan, of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yeah, please.
Okay, now, Mr. Galley, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Galley, you get your reset from our coordinator. Once you get your reset, and what's that court date? June 3rd. This case will be reset to June 3rd, 2026 at 9 a.m. Once you get your reset, you'll be free to go. And you have a blessed day. Yes.
Your Honor, would it be possible for Mr. Young and myself to appear via Zoom for that June 3rd setting?
Okay, let's see.
We're both out of towners.
I see this. This case is only 39 days old. So you can appear via Zoom on that day.
Both of us, Your Honor?
Yes,
Perfect.
on that day.
Thank you, Your Honor.
All right.
And this
Okay, you
is
can
my
get,
only setting. This is-
yes, you can get your reset. Once you get your reset, Attorney Holzman, you're free to go. And Mr. Gallo, you'll be free to go as well. And both you and your attorney, y'all have a blessed day.
Thank you, Your Honor.
All right. And
Yeah, I'm gonna let you know, Mr. Ali's on the video.
Okay. Raheel Ali? Oh, he doesn't hear me.
Yes, sir. Yes, sir. I'm here.
Okay, hold on a minute. We'll wait for for the prosecutor to come back.
Yes, sir.
Okay, just hold on. Okay.
Yes, sir.
Did he tell you what he wants to do on that one? Did he tell you? He's on the trial docket, page 4. Raheel Ali. Oh, there he is. Okay.
Thank you.
Okay, this is cause number 25 CCCR 0269. Case is styled the state of Texas versus Raheel S. Ali. And Mr. Ali is appearing via Zoom. Mr. Ali, how are you doing?
Yes, sir. I'm doing great, sir. How about you?
I'm doing fine. Thanks for asking. And Mr. Ali, you're represented in your case by your attorney. Is that Jonathan Landers?
It is, Judge.
And Mr. Landers, how are you doing?
I'm doing well, thank you.
That's good. And Mr. Landers, what is your announcement in Mr. Ali's case?
Judge, we previously announced ready and will still be ready whenever the court can get us to trial.
Okay, and the state? Landers. Okay.
The state is not ready on this matter, Judge.
Okay, so we'll give you a standard reset. Mr. Landers,
Yes, sir.
we're gonna reset it for trial. Once you get your reset,
Yeah,
you'll be free to go
all right.
and you have a blessed day.
Thank you, Judge. While I'm up here, Mr. Williams is gonna look at the case for me, and I appreciate that. Maybe we don't need a trial.
Okay.
Since we're both out of town, I heard there was a preferential setting for a gentleman who I think was on bond. Is that something that's possible?
Preferential setting.
I thought I heard someone earlier that kind of knew they were gonna go.
No, that's that was you talking about today.
Number one setting.
Today, right.
Yes, sir.
Okay, that's just based on the age of the case, so.
Right.
Okay, I was gonna see if there was like a date where we knew, everybody knew we were.
No, it was the age of the case.
Okay, and then I assume we need to be here in person next time.
Yeah,
Trial setting.
yeah, we don't know,
Yeah,
all of the cases that's gonna be on that
Okay.
particular docket.
I appreciate your time today.
Okay, just stay in contact with the prosecutor. Prosecutor
Yes, sir.
will keep the court informed as to the status of the case, whether it's y'all been able to work out a plea or, so.
And then I was gonna relate to you, I heard your last story. I had a trial a few years ago in
Yeah.
federal court, and my client was like 40 years older than me.
Uh,
But both federal agents picked me out as the defendant whenever asked. Yeah, I didn't say 40 years older, but we both had.
Yeah.
I was like. Thanks, Judge.
Can't
All right.
make that up.
All right. Okay, Maria Blackwell. Good morning, Ms. Blackwell. How are you doing? I'm doing fine, thanks for asking. Ms. Blackwell, you're represented in your case by your attorney, Attorney Langston Adams. Mr. Adams?
Doing well.
That's good. And let's see, Miss Mr. Adams, you was appointed on this case in January. January 8th, let's see. And Mr. Adams, what is your announcement? This is so what's your announcement?
I gave her the offer, she's aware of the offer, she asked me what I actually want, and we said, that's what you want, so.
Okay, we're gonna, this case,
That's a-
yeah, I give her a 2-week reset. Okay? Okay, so we're gonna, the case is gonna be reset, Ms. Blackwell, for 2 weeks.
It's in the systems.
Once you get your reset, you're free to go and you have a blessed day.
Thank you.
Okay, and Mr. Adams, you have Glenn Derrick Roundtree.
He's here.
Okay, this is Roundtree. How's it? December. December, okay. Mr. Roundtree, your full name is Glenn Derrick Roundtree.
Yes, sir.
How are you doing, Mr. Roundtree? That's good, Mr. Roundtree. You're represented in your case by your attorney Langston Adams. And Mr. Adams, what is your announcement in Mr. Roundtree's case?
Judge, on Mr. Roundtree, I was informed, he has the unlawful carrying, we do have an offer on that. But I was told that there's another case coming, it's another misdemeanor case, a drug case that's supposed to be in their system that's coming following this one.
You sure? What are they saying that it's happening on the same day or something, or who they looking in the system or something?
That's what that's what talked to the prosecutor, says another case coming. There's no me,
Oh, okay, well, we're not trying to, yeah, I can't see it from this side. They say maybe another case. Do we?
Want to see if it was on the same day. Maybe that would have made, Mike.
Because this happened in July. Wow. It must have took a while for them to arrest him, yeah. Yeah, this happened in 24. Yeah, it was a 24 case, but they didn't file it until 25.
Blackwell?
At the end of 2025.
Thank you.
Yeah, they issued a warrant in 2020, and case occurred according to this July of 24. They issued the warrant in June of 25, and he wasn't arrested until September of 2025. And then he bonded out September 25. And then, okay. Get an affidavit of indigency. Must have been, yeah, in 2025, December 2025, that's when that's when the attorney was appointed. Yeah, he must have had his arraignment in December 2025. Wow. Okay, they checking to see. you go. Salvador Isaac Mendoza Baraga.
Let me take a look.
Hi,
Mr.
Your Honor. How you doing?
I'm doing fine. How are you doing?
Doing good.
All right, and you representing your case by your attorney, Jared Gilthorpe. And Mr. Gilthorpe, how are you doing?
Doing well, Judge. How are you?
I'm doing fine. Thanks for asking. And Mr. Gilthorpe, what's your announcement?
Judge, we've announced ready on that one. We're still ready.
Okay. This case is far down the list. Yeah. Almost as far as you can go. It's the last case. Yeah, it is the last case on the docket.
Yeah.
So we have a number one setting. So we're going to the state before I do anything else. You ready on Baraga or?
263 days? No, sir, Judge. And it's a Class C appeal?
Okay,
No, sir.
okay. Well, Class C appeal is simple. It's not like it's that complicated.
Yeah, but it's only 293 days.
Huh?
And, Judge, the state have to prepare on like other cases where there are more serious issues, Judge.
Okay, I'm just saying, I was just asking, you might have wanted to go. I didn't ask before.
Judge, I have no objections to a reset.
Yeah, okay, I figured that. Like I told you, you was last on the list anyway. We got like 12 cases, so like 15. You was number 15 or 15. Okay, so we had to get to 14 before you. Okay, so this case is going to be reset. Give us a reset date. Okay, this case is reset to June 15th, 2026 at 9 a.m. Mr. Salvador Isaac Mendoza Baraga, stay in contact with your attorney. Your case is reset to June 15th, 2026 at 9 a.m. You're free to go, and you have a blessed day.
Thank you, Your Honor.
And now we get to the number 14 case on the docket. Robert Joseph Taylor Jr. And Mr. Gilthorpe, you have your same announcement, and State, do you have your same announcement?
Yes, Your Honor.
Yes, Judge.
Okay, so this case will also be reset till the 26th of, June 15th of 2026 at 9 a.m. And Mr. Gilthorpe, I think that these are your only two cases, is that correct?
That is correct, Your Honor.
Okay, you're free to go. You have a blessed day. And Mr. Taylor, you're free to go as well, and you have a blessed day.
You as well, sir. Thank you.
Okay, you're welcome.
Thank you, Judge. Take care.
You're welcome. Thank you. We already did Pulse, Roots. Miss. But no. Okay, Joshua Wade Allen. Is Joshua Wade Allen here?
He was having car trouble on his way and I'm trying to get him to zoom in right now.
Okay, we'll hold.
If you would just give me a couple minutes.
That's fine. Go hold.
I believe he's on the side of the road.
Okay,
He's
that's
trying
fine.
to manage a lot of
Okay.
things right now.
Okay, all right, you're welcome.
Mine is like June the 4th, so if we could get June the 4th as a announcement or plea date.
Okay, well, I think we probably did right after that, June the, well, you was resetting for June. What's the dates in June? On, page 3, of the announcement docket. Stephen Gutierrez. He's gonna apply for, pretrial diversion. And, we wants to have, set it in June, June 8th.
Sounds good.
Okay, this case will be reset to June 8th, 2026. Mr. Gutierrez, you'll get your reset from our court coordinator. Once you get your reset, you're free to go. And you have, hold on, let me look at this right quick.
The racing case.
Yeah, I know it's a racing. I was looking at the length of time on this here. That's she must already reset it. You already reset it?
Yes.
Okay, because I was gonna look and see how many resets we had on it.
It's, June 8th. If you go to June 8th.
Okay, this case is reset to June 8th. Once you get your reset, you're free to go and you have a blessed day.
Thank you, Judge.
Okay.
Thank you.
Yes, I think.
Catherine Robbins. Good morning. Yeah, Ms. Robbins, you can put your first there.
This is my first and only case. I spoke with the state, Your Honor, I spoke with Mr. Vernon. This is on the plea docket. It will plead. There was an issue with the video that I requested to get some resolution on. And so I'd ask for one more reset. This case will plead the next time we're in court. So you know,
Okay.
check one thing out about the video.
Okay, well, I'm gonna give her a 2-week reset.
Okay. Thank you, Judge.
Okay, Robert, give us a reset date. Okay, this case reset to May 18th, 2026 for plea. And Mr. Bailey, you can get your reset. Once you get your reset, you're free to go. And Ms. Robbins, once you get your reset, you're free to go. You have a blessed day, Ms. Robbins, and you have a blessed day as
Thank you,
well.
Your Honor.
Okay, you're welcome. Rock.
Wish I could still do it.
Yeah, they've been in the system for a while now.
Trevor Stratton. All right, how are you doing, Mr. Stratton?
Good morning.
Good morning, and how are you doing, Ms. Provo? That's good. Now, Mr. Stratton, your case is on the court's announcement docket, and Ms. Provo, what is your announcement in reset it for? This is Trevor Stratton, page 7 of the announcement document.
June 15th.
Case is reset for trial, June 15th, 2026. Mrs. Stratton, you get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day. And Ms. Provo, this is your only case.
Yes, you are.
You're free to go as well. And you have a blessed day. All right.
Thank you, Your Honor.
All right. Nice seeing y'all. Okay. Okay. Did he, okay, he's on
He's
Zoom.
on.
Okay, this is cause number 25 CCCR 0624. Case is style, the state of Texas versus Joshua Wade Allen. And Mr. Allen is appearing via Zoom. Mr. Allen, you can take your mic off of mute. That's not him. Mr. Allen, you can take your mic off of mute. And Mr. Allen is represented in his case by his attorney Reagan Minaldi. And Ms. Minaldi, how are you doing?
I'm good, Judge. How are you?
I'm doing fine, thanks for asking.
I'm talking with my office to figure out the muting situation. I don't know. Hopefully-
Oh, there it is. Mr. Allen, how are you doing?
Good. Sorry about that. I'm not real good with apps.
Okay, I understand. Now, Mr. Allen, you're represented in your case by your attorney Reagan Minaldi. And
Yes,
Ms.
sir.
Minaldi, again, how are you doing?
Good, Judge. How are you?
I'm doing fine. And Ms. Minaldi, what is your announcement in Mr. Allen's case?
I have received an updated offer in his case. I believe that's going to be a resolution for us. I just need to reset to review that with him and make sure that that's the direction that we're continuing.
Okay. Now, this case is, that's, you will,
If we need to put it on a different docket, Judge, we're fine with that.
I was giving you a quick reset so we can,
Yeah, sure.
Yeah, Ms. Segura,
Yes, sir.
could we give Mr. Allen, a 2-week reset?
May 18th.
Okay, this case is reset to May 18th, 2025, yes. And, Mr. Allen, your case has been reset to May 18th, 2025. Excuse me, 2026. You're gonna stay in contact with your attorney. Hopefully, your attorney was telling me that you was having some automobile issues. Hopefully.
Yes, sir. I'm still on the
Good.
side of the road.
Okay, we'll be prayerful that you get that resolved and that you are safe. Stay in contact with your attorney. You're free to go. And on May 18th, 2026, you need to be in court in person, and you have a blessed day.
Thank you.
You're welcome. And Ms. Minaldi, you can get your reset. You're free to go. I think this is the only case, right?
Yes, sir.
All right, you have a blessed day.
Thank you.
You're welcome. Ms. Mosby. Taylor Monet Neville. Mr. Wilkerson. Okay, go to in session and calls number 25 CCCR 1898. Case is styled the state of Texas versus Taylor Monet Neville. Ms. Neville, is that your full name?
Yes, sir.
How are you doing, Ms. Neville?
I'm doing well.
That's good.
How you doing?
I'm doing great. Thanks for asking. Now, Ms. Neville, you're represented in your case by your attorney, Marcus Wilkerson. And Mr. Wilkerson, how are you doing?
I'm well, Judge. Thanks for asking.
That's good. And let's see, we have Ms. Nixon from the state. Ms. Nixon, how are you doing?
Fine for you, Your Honor.
I'm doing fine. Now, Mr. Wilkerson, what is your announcement in Ms. Neville's case?
Judge, Ms. Neville has a pending matter in the CDC, and so we'd ask that this be set concurrently with that matter.
You have a date?
At present, I'm not certain that we do. Give me a second. So
are you representing on the
yes, Your Honor, I am representing her on the
felony?
as well. It's set tomorrow morning, actually. I don't think we're gonna dispose of it tomorrow morning.
Well,
but it is set tomorrow morning.
we have to reset it. We'll just reset it tomorrow, and then tomorrow, y'all can come back to court. Y'all gonna be here anyway, but when you finish down in the, check in here first, and then when you finish in the felony case, let us know what happened.
Yes, sir.
Okay, so it's set on, Cinco de Mayo. Okay.
Today is May the 4th.
Oh,
Yeah.
I didn't even think about
May
that.
the 4th.
Okay. May the 4th be with you. All right, so this case is reset till tomorrow, May 5th, 2026. Ms. Neville, do you pronounce it Neville or Neville?
However you want to say it.
Oh,
Neville, Neville, just however you want to say it. Some people say Neville, some people say Neville.
I know there's a group in that was out of New Orleans called the Neville Brothers. Okay, so they pronounce it Neville, but
The Louisiana people do say Neville.
because I think it's a French name. Louisiana was a French territory. Okay, so let's do this. Case will be reset tomorrow at 9 a.m. You can get your reset. Once you get your reset, you'll be free to go. And we'll see you tomorrow.
Yes, sir.
All right. And Mr. Wilkerson, this is your case?
I have one more, Your Honor.
And-
Travis Gage.
Oh, Travis Gage?
Do I have to get my receipt?
Yes. Okay, this case is on the pretrial conference docket. Hold on a minute. Pretrial conference. Trial. This is Gage. Okay, Mr. Gage, your full name is Travis Gage.
Yes, Your Honor.
How are you doing, Mr. Gage?
How you doing, Your Honor?
I'm doing fine, thanks for asking. Mr. Gage, you're represented in your case by your attorney, Marcus Wilkerson. And Mr. Wilkerson, let's see, I see that you were appointed January of
Yes.
2026, is that correct? Have you received your discovery?
Some of it, Judge. I have requested the medical records associated with the defendant's emergency detention.
Thank you.
I have not yet received those records
You requested them from the state or
Yes.
from the hospital?
from the state.
Do you know if the state have?
I'm not sure
state-
whether they have them. I just know he was transported there by law enforcement, and then released. So I'm gonna, I guess, issue a subpoena to the hospital. I'd also let the court know that in this case, if it goes to trial, I'm gonna have to secure a neurologist to testify And so we probably need a special setting, and I don't know if you want me to file a motion
You
to
have
have
to
the court pre-approve.
Oh, you have to file an
expenses.
accurate motion, yeah.
Yeah.
Okay.
Once the state have been able to thoroughly review the medical records within the case, Judge, if the state is able to make an independent determination of if mens rea was satisfied with this in consultation with the victim in this case, there may be a resolution, but I'm not in a position, having not reviewed the
Understand.
records.
Let me see, he was just appointed, okay. January, yeah. Okay, just, we'll give him a standard reset. And so you're in the process, now, are you gonna?
We'll do it both ways, Judge. I'll see about getting them medicals.
Well,
With the emergency detention.
yeah, I mean, that's his client's medical records. I mean, why you have to go to subpoena? His client could get his own medical records.
Well, obviously to use them in trial, they would need a
Well-
business records affidavit associated therewith, and
Okay,
so.
so we're gonna, reset it for, okay, just, let's reset it. Okay, give him a standard reset on Gage.
Is that on for trial?
Yes.
Okay, June 1st.
Okay, this case is set for June 1st, 2026. Mr. Gage, you'll get your reset from the court coordinator. Once you get your reset, you're free to go. And you have a blessed day. Okay,
Thank you,
okay,
Your Honor.
okay, and
Thank you.
yes, Mr. Wilkerson, you're free to go,
Thank
and
you.
you have a blessed day as well. Ian Leger. How you doing, Mr. Leger? That's good. Now, Mr. Leger, let's see, hold on a minute. I have 2 dismissals before me. He has 3 cases. No, 2 cases. Who is Shane Leger? That's another person.
Yes, Your Honor.
Okay. Now, Mr. Leger, the state has filed dismissals in your cases. Is that correct, Ms. Nixon?
Yes, Your Honor.
And I'm signing the. I think I wrote the wrong.
Mark. Yeah, one of them. So the one.
Yeah, on that. I think I wrote the wrong thing on, protect waters. I put April. And it's supposed to be May. I think I put it on, I just realized, I think I put it on both of them. On the protective orders. Did I write that?
You do.
Yeah. I just thought about it. Okay. I might have to just put the right date on it. And Mr. Leger, I'm signing these dismissals. Once I sign both dismissals, you'll be able to get a copy from our court coordinator. Yeah, both of them.
Oh, yeah. Right there. Both our hands, my-
Yeah, you have Havard. Okay. Okay, Mr. Leger. Just stand at the end of that counter. You can get your reset once you get excuse me, once you get your dismissals, you're free to go and you have a blessed day. Yeah. Now, hold on. I mean, I just looked at it. They just flat out dismissals. Okay, it's not dismissals. Okay. Let me see the dismissals. Make sure. This is 06. Okay, that's this one. Okay. That's what I was interested in. Okay, hold on. Oh. Okay. And your next one, you say Havard? Brandon Gardner? Yeah, okay. Now, Mr. Gardner, how are you doing? I'm doing fine. Mr. Gardner, I'm signing this motion to dismiss your case. Hmm? Okay. Good things comes to those who wait. All right, so your case has just been dismissed. You can get a copy of your dismissal. Once you get your dismissal, you're free to go. And you have a blessed day. Havard,
Gardner.
who's Havard?
Golden.
Yes.
Barney, we have just we did a forfeiture and it's gonna be dismissed. If we could.
Oh, he's doing the dismissal? Okay. Okay,
Do you need us to come up?
yeah, is it like a,
It's a forfeiture.
oh, got the forfeiture right here? Okay.
Yeah.
Who's the is she gonna, you can do it? Okay. 484. Okay, and sure, Brandon Chase 4. This is cause number 25 CCCR 1482, case of style of state of Texas versus Brandon Chase Forney. Mr. Forney, is that your full name?
Yes, sir.
How are you doing, Mr. Forney?
I'm good. How are you?
I'm doing fine. Thanks for asking, Mr. Forney. You're represented in your case by your attorney Corey Crenshaw, and Attorney Crenshaw. How are you doing?
I'm great, Your Honor. I just got back from the Bahamas and my client's case is getting dismissed. It's a good Monday, so.
Yeah, I know. That's easy. Well, I just got back from Houston.
Hopefully you missed the flood. You'll have a little water.
Yeah. And okay, so Mr. Forney, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. Now, Mr. Forney, I have before me a document that is titled Motion to Forfeit. Do you recognize this motion?
Yes, sir.
And is this your signature on the line as titled defendant?
That is.
Now, before you sign this document, did your attorney go over this document with you? And did you understand what your attorney went over?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Mr. Fernie, I'm signing this motion to forfeit the weapon in this case to the Beaumont Police Department and state I have before me a motion to, I don't have a motion. to dismiss. Okay. It hadn't been said yet.
No, yes.
Okay. Hold on a minute. I'll be getting a motion to dismiss this case in a few minutes. And once I get the motion, I'll sign this motion. You'll be able to get a copy of this motion and you'll be free to go.
Yes, sir.
And you can actually have a seat and have a blessed day.
All right, thank you.
All right,
Thank
and
you,
you'll be
guys.
free to
Good
go
to
as
see
well. You have a blessed day. Nice seeing you. court has a number one setting on it. It's not on your case.
Oh, I'm sorry.
It's on, Galmore's case.
I just forgot what was done.
Yeah, he was here, they already announced, so they're set to come back at 1:30. Now, let's see, I think the state said that you have Bailey
Your Honor.
Bailey and Hadley.
Actually, I had
Or-
Hadley is 2,
Hmm?
Bailey is 3.
You want me back at 1?
I'll have those two to come back, but your other folks, if you have,
1:30.
yeah,
Okay.
just in case.
Yes.
That's like some insurance.
Okay.
Okay, now you still have, Shane
Right.
Tyler Leger, that person, that person didn't show up.
We just had that case. I thought he was reset to the felony.
He has a felony, pending felony is today.
Oh, then he's probably over at drug court.
Oh.
I'll send him over. I haven't been, I wanted.
Okay, that's the,
Do you have a drug court here?
Yes, he should. Yeah, he's, I'll be over there. I mean, let me go over there and I'll have him come over here before I discharge him.
oh, okay. Okay, see all of these, I was saying, all these cases, that the felony. That's the ones that need to be activated. I know. That's what I'm saying. There's a whole bunch of, yeah.
Chains, keep those chains still.
What's wrong with it? Isn't that, Rife, where's Rife gone? Why don't you go get him to tell him to come back in?
Is Rife your attorney? What's his name?
Okay. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 25 CCCR 3040. Case is style of state of Texas versus Stardine Hampton. And Ms. Hampton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, help you God? Ms. Hampton, you may put your hand down. How are you doing, Ms. Hampton? That's good, Ms. Hampton. You're represented in your case by your attorney, Attorney Jennifer DeLage. Ms. DeLage, do you wait? First of all, Ms. DeLage, or how are you doing?
I'm good, Judge. How are you?
I'm doing fine. Thanks for asking. Ms. DeLage, do you waive a record in Ms. Hampton's case?
No waived, Your Honor.
All right. Ms. Hampton, I have before me a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Stardine Hampton, on or about October 18th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100 but less than $750. Ms. Hampton, do you understand what you have been charged with? And to this charge, how do you plead? Guilty, not guilty, no contest? Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Hampton, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there are a set of initials, SH, on a line next to a box that's checked. No contender, which means no contest. Did you place your initials in this document? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? You have to speak up. I also have a document that is titled Discovery Certification. And do you recognize this document? Is this your signature on the line that's titled Defendant? Ms. Hampton, before you sign and initial these documents, did your attorney go over these documents with you? Did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge? Ms. Hampton, are you a citizen of the United States?
State law for State's Exhibit 1.
No objection.
No objection. State's Exhibit Number 1 will be admitted. And Ms. Ledge, you have advised and counseled Ms. Hampton. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Hampton, your attorney has advised and counseled you. Are you satisfied with her representation? Has she provided full, effective, and competent legal representation? Ms. Hampton, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
What is the agreement?
The essential terms are as follows: 1 year deferred probation, $500 fine, 40 hours community service, and theft class.
What's the court cost? 287. Oh, court price. Okay, thank you. Okay, Miss Hampton. The state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $287. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County court-appointed attorney's fees of $350. Your total monthly installments. That is the total amount that you will be required to pay each month while you're on probation is $186 a month. Or you're able to pay the $186 each month. Okay. You will also be required to perform 40 hours of community service. You'll be required to attend and complete a theft class. And you'll be required to adhere to the other standard terms and conditions of this probation. Ms. Hampton, do you understand the state's offer? And do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Hampton, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Hampton, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure where your record will be sealed to the general public. You can talk to your attorney about a non-disclosure because she's quite competent in those matters. And Ms. Hampton, you're gonna stand next to the bailiff, follow her directions. Once you finish following her directions, you're free to go, and you have a blessed day. Board is following this plea bargain agreement. And let's see, Mr. Lage. You wanted me to hold on a Jason Bell?
I don't think he's here, Your Honor. I don't know that he has been. I don't think we checked in either.
He has professional bail bond. Have you tried to get in contact with us?
No, but I can do that right now.
Okay, that's fine.
Professional bail bond.
Okay. This is Jason Bell.
Oh, you check. Run as fast.
How are you doing? Okay, we just got word, we contacted the attorney. Apparently, he had a medical appointment. Obviously, he didn't inform the court. And so, let me ask you, are you working? Okay. So she doesn't work. Is he set tomorrow? Hold on a minute. I know we have a rain. Stephanie Renee Anderson.
He's present, Your Honor, and the
What's
bill
that?
here, that case is being dismissed for forfeiture of a weapon.
Oh, somebody raised their hand?
That's her. You
can Oh.
come up here, I know, she's in the chair.
Yeah, no, inconvenient. Yeah, she can. Okay, you can come on up. Stephanie Renee Anderson. See, it's set with a felony.
Yeah, we just got through pleading the felony.
Yeah.
Oh, y'all disposed of the felony.
Felony, right, Judge, this matters to be dismissed. I'm filling out the dismissal, and here's the forfeiture of the weapon.
Okay,
case.
now, Miss Anderson. How are you doing?
Okay.
That's good. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. Now, Ms. Anderson, I have before me a document that is titled forfeiture, a motion to forfeit. Do you recognize this motion?
Yes, sir.
And is this your signature on the line that's titled defendant? Before you sign this document, did your attorney go over this document with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, Ms. Anderson, I'm granting this motion to oh, they don't have a, agency that is being forfeited to. Yeah, we do.
I neglected to write that down. Rest of the agency was among those.
Yes.
Thank you.
Okay. Okay, now, Ms. Smith, I'm signing this motion. An order?
Thank you.
I'm signing the order, rather. And forfeiting this weapon to the Beaumont Police Department. Here you go. And
And I have sent it over to you.
okay, he's sending a motion to
Yeah, I have them.
dismiss. Okay, and so Anderson, Stephanie Anderson. Okay. Ms. Anderson, I'm signing this motion to dismiss this case. The attorney will be able to get a copy of this motion. He can give it to you. Once you get a copy, you're free to go. And you have a blessed day. You're welcome.
Give it to you. Probation.
Okay. Let's see, I just did that. Hmm? Okay. Donald Eaglin. Let's see, Donald Eaglin. Mr. Eaglin, this is cause number 24 CCC Aura 2211. Case to style the state of Texas versus Donald R. Eaglin. And Mr. Eaglin, how are you doing? I'm doing fine, thanks for asking. Now, Mr. Eaglin, you're represented in your cases by your attorney, Bruce Smith and Mr. Smith. What's your announcement in Mr. Eaglin's case?
No, we're waiting on the blood discovery. We have not received the blood discovery yet.
Hold on a minute. What is that? This case was transferred. Well,
Let me,
yeah, it was transferred from County Clerk Law number 3. I don't see a notice of order for, okay, right before it was transferred, oh, that's been over a year.
I'm getting pretty sick.
Almost a year.
Oh, I see the order was signed February 25th, 2025.
Oh, then it was over here. I was thinking September.
Driver.
There must just be like a,
Same driver.
I'll follow up on that, Judge. There must.
I know they were having
Mechanic
difficulties prior.
Yeah. What do they have to do to get the blood discovered? I'm trying to figure out, because I know it goes to the DA and the DA has to send it to the lab or something. How that
Well,
work?
and
How does
it
it
will
work?
go to the forensic scientist who had performed it. I'm not certain. I know one forensic scientist is no longer there, and we would have had to redone.
Oh, yeah, they had to
from-
retest it?
Yeah, and I just don't know the particulars on this case, Judge. To why it's been a year. Normally it don't take that long. But I
Yeah.
will look into it further.
I guess we have to give it a standard reset.
What is that?
This is,
And the court has
even-
signed like the order, right?
that order, yeah, I'm looking at it right now, signed February 25th, 2025
Okay.
by Judge Woods. So
Okay.
whoever that prosecutor over there was, they should have started the process before it was transferred over here.
We'll make sure the blood order gets to the left. And if there's any other issues, I'll be sure to let Mr. Smith know.
Okay, blood warrant. June 3rd. Okay, this case is reset to June 3rd, 2026. Yeah, Mr. Eaglin. You can get your reset from our coordinator. Once you get your reset, you'll be free to go. Actually, I could probably see what happened. Right after that was signed, they transferred the case 3 days later. So the prosecutor probably didn't relay the message to whoever got the case over here. That's the only thing I can figure out.
Well,
I mean, I don't know.
been brought up here before
Okay,
by you.
okay. Okay.
To other-
No worries. I will take responsibility.
But they'll be-
Make sure that it's good.
But not to this prosecutor.
Yeah,
It's okay. It's one office.
yeah,
You're kind, Mr. Smith.
okay. Pedro Martin Esquivel Jr. What's the deal on this one?
Now give it, Mr. Smith in his office,
He must have just been
due
hired on
respect,
this one.
Judge, and,
He was just hired just a few weeks ago?
Yes, Your Honor, and we have received the discovery. We just haven't had a chance to go through it.
I just tendered the discovery today.
Okay,
I just tendered the discovery this morning, Judge. And
okay, so
no
yeah,
fault of Mr. Smith. He requested it weeks back. I just got around to it today.
okay, okay. So we're gonna give him a standard reset?
Yes, Your Honor.
Okay. This is Pedro Martin Esquivel Jr. Is that correct?
Yes, Your Honor.
Okay, this case is reset to June 3rd, 2026. Once you get your reset, you're free to go. And you have a blessed day.
You do.
Just have a seat, no problem.
Joseph Morris Zachary Jr.
That's the same problem.
I see, I'm looking at, this notice the blood rate was October. It must have, yeah, it's the same week.
Yeah.
October 20 to 2025.
It's exactly the same time.
Okay.
And we
This is
published,
Mrs. Zachary.
Yeah,
Joseph Zachary.
was this, hold on, whatever. Was this? Let me see. Yeah, it was signed October 20th, 2025. And so this one's been in this court, so, well, it's just October 2025. Okay, well, yeah, so it wasn't, that other one was like a February 2025, wasn't it?
That's correct.
Okay, so this one was like October. Hey, almost 7 months. And we had, so you're gonna look into this one too?
I will, Judge. These two men.
Yeah. October 20. Yeah, because I've seen Mr. Zachary here a couple of times. Okay, this case, give us let's put them on the same date. Okay,
Yeah.
yeah, gonna be on the same date of that other case, so they'll come up together, so. All right. You gonna get your reset, Mr. Zachary, from our court coordinator? Once you get your reset, you're free to go and you have a blessed day.
Now, is there, my client has asked me, is whether or not there was an alternative with you to the interlock. He's having.
Oh, it's DWI second.
Yeah, I understand,
Yeah.
but I'm just asking, he's having great deal of trouble being able to blow into it. And so I'm asking whether there was any alternative to that would satisfy the court.
A scram, wouldn't it?
I don't know. What we can do, we probably can have I think probably just follow the motion, have a hearing on it.
Yes, sir.
So we can get
I'll do that.
more information on it, okay?
Okay, thank you.
All right. All right, okay. Well, if you take a break, okay, we'll be in recess.
The, um, the standard conditions of, the standard conditions of his bond, Judge. realizing this is a Class B trespass, it is that of assault. I'm sorry,
Assault.
it is of the family violence variety, Judge.
Hold on a minute.
I just couldn't find any.
Hold on a minute. Let me take a look at this. This is on the announcement docket,
Correct, Judge.
and this is Young,
Yes, sir.
Parazzo, Jason. Hold on, let me take a look at this here.
In our system, we put in given a complainant and a related.
Let me look at the PC.
Sure.
Hold on a minute. Hold on, let me take a look at PC. Mr. Young, your attorney just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And it states as follows: following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? You have to speak up.
Yes, sir.
Okay. Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
Okay, now condition number 3. The defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. And
Cecilia Garcia.
let me put that on here.
Just
Just a minute.
Okay, do you understand that?
Yes. Does he
Okay.
understand that he can't, I'm sorry.
And he can't communicate directly or indirectly, not even by social media, through a third person. You can't communicate directly or indirectly with, hold on a minute.
She can put it tomorrow. She can do.
She's still in Garcia.
She could get somebody else to drop the kids off. If that's what you're concerned about. Hold on, sir. Hey, I'm Judge Holmes. You don't call me man.
I'm not talking.
Okay, you wasn't talking to her. She not a man.
It's just a figure of speech.
Ain't no figure of speech. Okay, we from the same place, okay? Okay, I'm from the same hood you from. Okay, so don't come in here trying to play no game. Okay, is it Cecilia Garcia? Okay, so I'm gonna read this condition again. Defendant shall not communicate either directly or indirectly with the alleged victim, Cecilia Garcia, of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
Your Honor, I need to point something out. One of the
Okay.
things that Mr. Young was trying to have the court understand, I believe that Ms. Garcia actually works downstairs.
That's correct. There's no reason.
Okay, he still can come to,
County.
yeah.
There's no, reason for him to go to her office or about that judgment.
Well, I just want to make sure that.
Other location, they have residence, school, or other location. Well,
Where she's at.
Well, it's
Her
different him coming to court and if he's going down to.
right,
clerk's
he can
office,
come to
whatever.
court. Yeah,
Okay,
yeah, it's not gonna stop him from coming to
I just wanna make
court.
sure that everybody is aware.
But if you do a frolicking detour and
No,
go down to our office, we'll have a problem.
Okay, Judge, if we continue, we're gonna ask for a
So
hearing.
this is something,
Different column.
so basically this would pertain to the no contact order and what I was just relaying to the court and a potential issue.
Okay.
Could you please explain to the judge what happened the last time that you came here and she was
No,
here?
no, sir, Judge, not
Well,
without
hold on, hold on.
their oath and.
Hold on, yeah, we
Judge.
need
We're
to,
not gonna
I
have
mean,
like
we
a
can
hearing
have,
on
yeah,
this.
we'd
To
have to,
disparage the.
yeah, we'd have to have a hearing. So what I'm gonna do, right now, this order is gonna be the order of the court. If we're going to, if you wanna do any modifications, we have to have a hearing on that later on, but not right now. Okay,
It's not necessarily a modification that we would be requesting, Your Honor, but just an issue I think that the court needs to be aware of.
what the court also could need to be aware of, since we're having this informal thing, he's been having numerous contacts, Your Honor, with the complainant, going to the complainant's church, etc., with like the kids, and blatant violations of this court order. The reason why the state has humbly requested that the man has conditions put in place is so he can understand unequivocally what he is supposed to do and not do. You can see from the person who appears before you now, he is defiant of the court's orders as he's standing here. If you go through the conditions, Your Honor, we will not have until we're set for an actual hearing, the disparaging of the mother of his children, of the complainant within this case.
Okay, Your Honor, I guess the issue is the last time that he came here, according to my client, and she saw him, he started sending text messages to various family members and friends and members of the community and accusing him of, doing things when he was strictly simply coming up the stairs.
Okay, well, he'll be allowed to come to court. We can't stop him from coming to court. Okay. All right. So you just, as long as he just, come to court like he's required to do. Now, as I mentioned to you, condition number 3 is defendant shall not communicate either directly or indirectly with the alleged victim, Cecilia Garcia, of the pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Yes. Okay. Now, condition number 5, number 4 does not apply. That only applies in the DWI case. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes. Yes.
Okay, now, Mr. Young, if you violate any one of these conditions, your bond will be revoked. And once your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? All right. Now, your case has been reset. We're going to reset it for trial. Is that correct? Give us a trial date.
We asked for a 2-month setting. That agreeable?
They want a 2-month reset for trial. This is
June 29th.
okay. This case is reset for trial June 29th, 2026. Case set for trial June 29th, 2026. Once you get your reset, you're free to go. You have a blessed day. And Miss Razo, you'll be, I think this is your only case. You're free to go as well. And you have oh, she has a plea? Okay. And that is on Elias Anthony. Yes, Anthony Elias. What happened? Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 25 CCCR 2060. Case is styled the state of Texas versus Anthony Elias. Mr. Elias, is that your full name?
Yes, sir.
Mr. Elias, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Elias, you may put your hand down. How are you doing, Mr. Elias?
Doing good, sir, by yourself.
I'm doing fine. Thanks for asking. Mr. Elias, you're represented in your case by your attorney, Lori Perazzo. And Ms. Perazzo, do you waive a record in Mr. Elias's case? Mr. Elias, I have before me a document on my computer that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Anthony Elias, on or about June 13 of 2025, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas. Mr. Elias, do you understand what you've been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, no contest?
Oh, no contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Elias, I also have before me a document on my computer tablet that is titled misdemeanor plea admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials, AE, on a line next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Elias, before you sign and initial these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes, sir.
State, do we have a plea bargain agreement?
We do, Your Honor.
No, just state, would you like to offer State's Exhibit Number 1? That's what I'm.
I was waiting for it, Judge. Yes, they will attend the State's Exhibit Number 1.
Okay, I got ahead of myself. And no objection, State's Exhibit Number 1 will be admitted. Now, Ms. Perazo, you have advised and counseled Mr. Elias. Is there any evidence that he is currently mentally incompetent to stand trial?
No, sir.
And Mr. Elias, your attorney, Ms. Perazo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Mr. Elias, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Now, State, what is
Yes,
the
we
plea
do.
bargain agreement?
It would be 15 months deferred adjudication, Your Honor, a $250 fine, interlock device, 40 hours of community service, and the state will not oppose to the matter being transferred during the intrastate compact to where it be transferred to Travis County. Is that correct, Ms. Perosa?
I believe it's not Travis County anymore, but it is a county that is over,
Collier County?
yes.
Yeah.
Somewhere near
Yeah,
Austin.
okay, yeah, the probation office, they'll work that out.
Yes, sir.
Let's see, this is,
And that's correct.
now, were you appointed in this case?
Yes, sir.
Okay,
Or possibly 92.
392. And 250. This is 225. Okay, Mr. Elias, the state is offering that you serve 15 months deferred adjudicated probation during the 15-month probationary period. You'll be required to pay a fine of $250 plus court costs of $392. You'll also be required to pay a DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. You'll also be required to pay DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. And your total monthly installments in this case is $159 a month. Will you be able to pay the $159 each month? Okay. Let's see.
So you can, so.
Oh, okay, I'm looking at I have a document before me that is titled Jefferson County Affidavit of Injuries. I'm gonna hand this document to your attorney and she will hand it back to you.
Everything's the same. Has anything changed as far as your income and your expenses?
Expenses probably increased a little bit more.
Okay.
It's my mortgage.
But you're not currently receiving income as of today? Yes, okay. So could you put what you're receiving? And do you want him to put a line through?
Yeah, you put a line
Okay.
through it, that's fine.
And just initial it. And then whatever your increases in your expenses. And put them through it and then initial. Oh, you want to-
Oh, yeah.
Okay. Have any of these changed in value? So then that value will change if since that one went up.
Thank you.
You're welcome.
It's gonna be. Okay. Okay, Mr. Elias, I have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is everything on this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Elias. Court is going to find that you're indigent. Based on the finding of indigency, the attorney's fees in this case of $350 will be waived pursuant to Article 26.01 of the Texas Code of Criminal 26.05 G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. The probation, that's not probation. The fine of $250 plus court costs of $392 will be converted to 51 hours of community service. You will be required to pay the $100 conviction fine fee. You'll be required to pay a probation fee of $60 a month, a reimbursement, and urinalysis fee of $15 a month. So your total monthly installments in this case will be $87 a month. Now you'll be able to pay the $87 a month. Okay? You'll also be required to perform 40 hours of community service in addition to the 51 hours of community service that was converted from the fine and court costs. And so it comes to a total of 91 hours of community service. You'll also be required to install an interlock device on any vehicle that you own or operate, attend a completely DWI education class, have an alcohol assessment, and adhere to the other standard terms and condition of DWI probation. Mr. Elias, do you understand the state's law?
Yes, sir.
And do you understand the findings that the court have made in this case?
Yes, sir.
And do you accept the findings and the offer?
Yes, sir.
Okay, Mr. Elias, I'll follow the plea bargaining agreement that you have made with the court's findings. If you successfully complete this probationary period, the case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because she's quite competent in those matters. You can stand next to the bailiff or have a seat. Have a seat in that first chair and wait for your name to be called. Yes.
Sorry. Judge, I just said Bell. You recall we were having the bailiff call and then we.
Yeah,
touched
Bell,
base.
Jason Bell.
Yes, sir. We touched base with Belmont's place when they did confirm with them. He's in the hospital and they just sent over records.
Oh, they did? Okay, so we just need to give him a reset.
Yes, Your Honor. Which one?
He's
Jason
on
Bell.
page 2, well, he's on the announcement.
Announcement docket, but. Somewhere, alphabetical order affiliation.
Okay, you wanna reset it?
Excellent work.
Give us a standard reset.
I mean, if you just wanted to.
This
say
is,
something.
oh, well, Jason Bell, you can just, when you get a chance, you just give her a reset. She's gonna send you your reset. Ms. DeLage?
Yes, sir.
She's gonna send you your reset.
Okay, that works. You know, they like it better that way. Thank you, Judge.
Okay,
Free to
yeah,
go?
you're free to go.
Thank
You have a blessed day.
You want to go something?
I think we have Mr. White.
Oh, yeah. Thank you, Judge.
I have a plea for Mr. Burns. Yeah, yours is ready, I think.
Is that Justin Downs?
Yeah.
Justin Downs? What docket is she? File docket?
It's actually got 2 causes, but they're pleading to the one on the trial docket, the other one's being dismissed as part of the thing.
Okay, which, hold on a minute. Downs, we plead the 22. Mr. Downs, Mr. Downs. Okay, Jefferson County Court at Law number 2 is in session and cause number 24 CCCR 2522. Case of style of state of Texas versus Justin Thomas Downs. And Mr. Downs, is that your full name?
Yes, sir.
Mr. Downs, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Downs, you may put your hand down. How are you doing, Mr. Downs?
Good, Judge.
Oh, I'm doing fine. Thanks for asking. Now, Mr. Downs, your attorney of record is Ryan Gertz. Attorney Gertz is not here. However, standing in for Attorney Gertz is Attorney Reagan Minaldi. Does Ms. Minaldi have your permission to stand in for Attorney Gertz?
Yes, sir.
And Ms. Minaldi, how are you doing?
Good, Judge. I'm getting a little hungry.
I understand that. I'm doing the same. And Ms. Minaldi, well, the state is represented in this case by Attorney Fred Vernon. And Attorney Vernon, how are you doing?
I'm doing well, sir.
That's good. Now, Ms. Minaldi, do you waive a record in Mr. Downs' case?
Yes.
Mr. Downs, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Justin Thomas Downs, on or about May 21st of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more while you operating a motor vehicle in a public place in Jefferson County, Texas. Now, Mr. Downs, do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead guilty, not guilty, no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Downs, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Downs, before you signed and initialed all of the documents that I'm showing you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge?
Yes,
Mr. Downs, are you a citizen of the United States?
Yes, sir.
State, would you like to offer state's exhibit number 1 into evidence?
So moved, Your Honor.
Any objections? No objections. State's exhibit number 1 will be admitted. Ms. Minaldi, you've advised in counsel, Mr. Downs, is there any evidence that he is currently mentally incompetent to stand trial?
No, Judge.
And Mr. Downs, your attorney, Ms. Minaldi, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation? Mr. Downs, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor, we do. With regard to the current cause number, it'll be 90 days probated over 1 year, $500 fine, 60 hours community service with the standard DWI conditions, including interlock. And then In addition to that, the state has agreed to dismiss cause number 25 CCCR 0321 in exchange for the guilty plea on.
Okay. What's the court?
377.
377. Okay, Mr. Downs, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $377. You'll be required to pay a DWI conviction fine fee of $100. You'll be required to pay a probation fee, $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to pay Jefferson County DWI education an initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $172 a month. Will you be able to pay the $172 each month?
Yes, sir.
You want? Does he have a an affidavit? Gertz wasn't appointed in this case, was it?
No, he was hired.
Okay. She's gonna print off, you're gonna check to see if he has one? I'll check to see if he had filled out one while he was in. You know what? I don't think there's one because I don't see, no. Okay, we're gonna have to give him one. Fill out. Y'all can have a seat at that table. At the council table, you can fill it out and then y'all can come back up. Bye.
Right there.
Yeah. Okay, that's his, oh, he's on pretrial, okay. Pretrial. White, let's see, Hall. How do you pronounce your middle name?
Swan.
Swan? Swan, okay. Vu Swan Hong, okay. Here we go. Jefferson County Court at Law number 2 is in session and calls number 25 CCCR 0660. Case is South State of Texas versus Vu Swan Hong. Mr. Hong, is that your full name?
Yes, Your Honor.
Mr. Hong, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Hong, you may put your hand down. How are you doing, Mr. Hong?
I'm doing good, Your Honor.
That's good. I'm doing fine. Thanks for asking. Mr. Hong, you are representing your case by your attorney, Brock Anthony White. And Mr. White, or Attorney White, how are you doing?
I'm doing well, Your Honor. How about yourself?
Oh, I'm doing fine. Thanks for asking. And Attorney White, do you waive a record in Mr. Hong's case?
I do, Your Honor.
Mr. Hong, I have before me on my computer a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. This information alleges that you, Vu Swan Hong, on or about, on here it lands, Swan Vu Hong, on or about January 21st of 2020, January 21st of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated, while you were operating a motor vehicle in a public place. Mr. Hong, do you understand what you've been charged with?
Sorry.
And to this charge, Mr. Hong, how do you plead guilty, not guilty, no contest?
Please.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yes.
Mr. Hong, I also have before me on my computer tablet a document that is titled, let me do this here. I'm gonna back up. Is your name Vu Swan Hong or Swan Vu Hong?
So on my license, my first name is Swan, but
Okay,
yeah. So
okay, well, they charge you with, okay, it's Swan, so okay. Let me do this here, because on the information, it has Swan Vu Hong.
yeah.
Okay, let me correct that on here. How did it come out on the judgment? You still tapping it? Do they have an AKA? Oh, is one of the AKAs his?
Middle name first?
Yeah.
Yeah.
Okay, well, we could leave it like this then. We didn't have to do anything. Okay, we didn't have to do anything to it. As long as it came out that way. Okay, so let's see. I have before me a document that is titled misdemeanor plea admonishment, is also labeled as State's Exhibit number. Now let me back up. Now, how did you plead to this information? Guilty, not guilty, no contest? Guilty. And also have before me a document that is titled misdemeanor plea admonishments. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials on a line next to a box that says guilty. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that's titled defendant. This is your signature. And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled discovery certification. You recognize this document? And is this your signature on the line that's titled defendant? Mr. Hong, before you signed and initialed these documents, did your attorney go over these documents with you? And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Hong, are you a citizen of the United States?
They offer State Exhibit 1.
Any objections?
No objections to State's Exhibit number 1, yeah.
No objections. State's Exhibit number 1 will be admitted. Attorney White, you advised and counseled Mr. Hong Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor, there is none.
And Mr. Hong, your attorney, Mr. White, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Mr. Hong, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The essential terms are as follows: 90 days in the county jail over 1 year probation, $300 fine, 40 hours of community service, and DWI first standard conditions and terms.
What's the court cost?
$392.
392, 720, 180, 15. 6, 7. Okay, Mr. Holmes, the state is offering that you serve 90 days in Jefferson County Jail, but you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you're required to pay a fine of $300 plus court costs of $392. You'll be required to pay a Jefferson County DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is a total amount that you will be required to pay each month while you're on probation, is $155 a month. Will you be able to pay the $155 each month? You'll also be required to perform 40 hours of community service, attend and complete a DWI education class, have an alcohol assessment, and adhere to the other standard terms and conditions of DWI probation. Mr. Hong, do you understand the state's offer? And do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Mr. Hong, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Hong, you're gonna stand at the end of the counter, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go. You have a blessed day, and Attorney White, you'll be free to go as well. And you have a blessed day. Nice seeing you.
Thank you, Your Honor. Nice seeing you, Your
And
Honor.
have a safe trip back.
Yes, sir. Thank you.
You are. You're welcome. Mr. Downs? They have it?
Right there.
Okay. Okay, Mr. Downs. I have before me, let's see, that's the affidavit. Let me see. Let's see. Downs.
Oh, we had programs. Yeah, thank you. Yeah. All right, so there, last right now, every time I had 115. So
Does he? Let me do this shit. That's 15. That's 15. That's gonna be.
So Jared was, oh, yeah. This morning.
Okay, Mr. Downs, I have before me a document that is titled Affidavit of Indigence. And do you recognize this document?
Yes, sir.
And is everything on this document true and correct to the best of your knowledge? Okay, Mr. Downs, the court is going to find that you're indigent based on the finding of indigency. The fine in this case of $500 plus court costs of $377 will be converted to 70 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. You will be required, well, also the reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. You will be required to pay $100 DWI conviction fine fee. The probation fee in this case of $60 will be reduced to the statutory minimum of $25 a month. And you'll be required to pay your analysis fee of $15 a month. Your total monthly installments in this case is $53 a month. Will you be able to pay the $53 each year?
Yes, sir.
Okay. You'll also be required to install interlock device in any vehicle that you own and operate. Attend a completed DWI education class, have an alcohol assessment. You're also required to pay Jefferson County DWI education initial evaluation fee of $125. And as I mentioned to you earlier, you will be required to adhere to the other standard terms and conditions of this probation. The state will be dismissing cause number 25 CCCR 0321, the companion case. Now, Mr. Downs, do you understand the state's offer and the findings that the court have made in this case?
Yes, sir.
And do you think that is fair and just?
Sir.
And do you accept it? Okay, Mr. Downs, I'll follow the plea bargain agreement with the findings in this particular case. Now, Mr. Downs, you're gonna have a seat in that first chair. Wait for your name to be called because she needs to adjust the paperwork. Yeah, his total hour community service, yeah, with 70 hours converted for fine fees and costs, it comes to a total of 130 hours because you're required to perform 60 hours of community service in addition to the 70 hours that was converted from fine fees and costs. Do you understand that?
Yes, sir.
All right. All right. Just have a seat in that first chair on the wall and wait for your name to be called. You'll be able to get a copy of the judgment and the dismissal. And Ms. Minaldi, you are free to go,
Thank you.
and you have a blessed day.
You too.
Thank you.
Your Honor,
Yes,
state having no more business, and we're free to go for lunch.
yes, you free to go, and y'all have a blessed day.
We don't have any fun. Oh, cheers.
I don't, thanks. I don't think so, because the one we had, that ended up, that person is in the hospital. Yeah, the one we had, that person is in the hospital.
So, I just had.
They sent over, they emailed
The bond.
the bonding company emailed information showing the court that he was that person was in the hospital. And let's see, I think we need to get, I guess when he comes back, Kenise was supposed to put 2 other cases on the docket, those 2 dismissals, the ones from last week. You know,
Oh, Shaw and,
Ruben.
Ruben.
Yeah, I guess he'll do that when we come back.
Dismissing TRPs.
Yes,
I'll do them if you want me to, or y'all want to do it later.
when do you want to do?
We in here now, if you have.
Okay.
I mean, if you don't,
Okay, you gotta put them on the docket, though, huh?
yes, I will. Oh.
Okay, all right.
First. First peptide has been out for 80 years, and it's used by millions and millions, and not hundreds of millions of people across the world.
Hey, Mr. Y'all gonna have to be quiet. We get ready to get started.
Yeah, I'll just, I'll be out there in a second. I gotta hang on.
Mr. Boudreaux,
Yes, sir.
you're gonna go to that first row of chairs and you're gonna walk all the way to the end, to that first chair.
Right here, sir.
Yes, you can have a seat. Miss Alexander, you're gonna sit next to Mr. Boudreaux? Yes, he's Mr. Boudreaux.
I just gotta hang around for this.
Ms. Carter? Okay, Ms. Carter, you will sit next to Miss Alexander. Mr. Arredondo, you'll sit next to Miss Carter. Mr. Campbell, you'll sit next to Mr. Arredondo. Walton, sir, you have to remove your hat. And you're gonna sit next to Mr. Campbell. Ms. Jeffers? Yes. You'll sit next to Mr. Walton. In the first row? Yes. Yes. Ms. Benvenue, you're gonna come up to the first row chairs, and you're gonna sit in that first chair right there. Did Ryan Holmes show up or? Ms. Lee, you're gonna sit in the first row of chairs. There's a chair between you and Ms. Bienvenue. Yes. Ms. Bonner, you'll sit next to Ms. Lee on this first row. Ms. Davis, you'll sit next to Ms. Bonner. She's getting ready to sit down. You're gonna sit in the chair that has next to her. Yes. And Ms. Alford, you'll sit next to Ms. Davis on this first row. Mr. Downs, you'll sit next to Ms. Alford on the first row. Mr. Boras, you're gonna go to that second row of chairs, right there, second row, and walk all the way down to the end, to that first chair in that second group. Mr. Hoffpauir? Yes. Just follow Mr. Boras down the second row. Aguilera Perez, you'll follow Mr. Hoffpauir. Mr. Gutierrez Tavares, you'll follow Ms. Aguilera Perez. Yeah, sit in the chair next to her. Okay, Mr. Alexander, you're gonna go in that second row of chairs right there and walk all the way down to the end. You're gonna sit next to Mr. Gutierrez. And Mr. Peacock, you'll sit next to Mr. Alexander, the second row of chairs right here. Okay. And good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for a criminal jury trial. Our courtroom hours normally vary from 9 a.m. to 5 p.m. Now, in County Court at Law Number 2, we have dockets in the morning. Oh,
I have
jury number 9. Oh. Okay. So, okay, again, ladies and gentlemen, I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for a jury trial. It is a misdemeanor criminal case. Felony cases are divided into, criminal cases are divided into felonies and misdemeanors. Now, your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as petty offenses. It does not mean that they're not serious. It just means that they are not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, you will be examined for inclusion on this jury trying this felony case. Our quorum hours normally vary from 9 a.m. to 5 p.m. Now, in this court, we have our dockets, and our dockets is just a list of cases that we have, and we have those normally in the morning starting at 9 a.m. And most of the time we have cases like this morning, we had a pretrial conference docket, a jury trial docket, and an announcement docket. All three of those dockets, and so when you total all of those cases up, you are well above 50. So we have more than 50 cases in this court this morning. Now, because we have our dockets in the morning and we have all of those cases in the morning, it is not uncommon for us to finish after 12 noon. This afternoon, we finished somewhere around 1 o'clock. And so this case was scheduled to start at 1:30. Now, so because we have cases like that, we usually start our jury trials once we know the case is going to trial. We have our jury trials in the afternoon starting at 1:30. So our quorum hours is normally the trials 1:30 to 5. And if we need to go a little past 5, we'll let you know. If not, then the case will be reset for us to come back the next day at 1:30. Sometimes if we do not have a lot of stuff in the morning, we may have you come back a little earlier than 1:30, but normally it's 1:30 to 5. Now, whether or not you're selected for to serve as a jury in this case, you should be mindful that you're performing a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which will require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate yourselves for recess, for meals, and at night. Now, at this time, I must administer to you the first of 2 oaths. So at this time, I need everyone to raise their hand, raise your right hand, and then once I finish administering the oath, please say, "I do." Do each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service, qualification as jurors, so help you God? Please say, "I do." Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you can be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications to serve as a juror in this criminal case. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail up to 180 days and fined up to $500. Now, the way I'm going to ask the questions, I will ask you a series of questions. I do not want you to answer those questions out aloud. Just answer the question to yourself. And once I finish asking the last question, I will then ask if there's anyone who is disqualified under the law. And if you think that you may be disqualified under the law, I will ask that you will come up before the bench and you'll stand to my left, which will be your right side of the bench. And then I will ask you questions outside of the presence of the other jurors. Now, when I use the term outside of the presence of the other jurors, we want to do that. We will ask the questions more privately. And so right now we are airing on YouTube. We have the microphone on, so YouTube will be turned off, the microphone will be turned off, and I will turn on this noise sound device. And then we will discuss the matter outside of the presence of the other jurors. So again, I'm going to ask a series of questions. I do not want you to answer those questions out aloud. Just answer the question to yourself. And then when I ask the last question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, I'll ask you to raise your right hand and then we'll call you up one at a time. First question, except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the laws and constitutions of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I pause before I ask this next question because I need to inform you that I'm required to ask this question by law. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Is anyone disqualified under the law? If you think that you may be disqualified, please raise your right hand. Okay. Let the record reflect that no one have raised their hand. Okay, now I will proceed to exemptions. I will determine if anyone who is otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just continue to remain seated. Now, I will ask these questions in the same manner that I asked the previous questions. That is, I will ask a series of questions and you can answer those questions to yourself. You do not need to answer those questions out loud. And then when I ask the final question, I will ask if there's anyone who would like to claim an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12? And jury service will necessitate leaving the child or children without adequate supervision. Are you a student in a public or private secondary school? Are you enrolled in actual attendance at an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the past 3 years preceding today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces, serving on active duty and deployed to a location away from your home station and out of Jefferson County, the county of your residence? If any of these exemptions apply to you and you would like to claim an exemption, please raise your right hand. Okay. We have juror number 10. Okay. And that's Miss Lee. Is that correct? Miss Lee, would you please come forward? Is there anyone else on the panel who's claiming an exemption? Okay. Okay, now we will move to excuses. With the excuses, I'm not going to ask any questions. I'll make 3 statements. And if any one of these statements apply to you and you would like to claim one of the excuses based on the statements that I make, When I ask if there's anyone who'd like to claim an excuse, just raise your hand and we would ask that you would come up before the bench. And the first statement. A judge may, a juror may be excused for observance of a religious holiday upon the completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. And the last statement, a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse. No one else on the panel is claiming an exemption. And at this time, all members of the panel are qualified. Let the record reflect that the time now is 2:13 p.m. on today's date of May 4th, 2026. The court is in session in cause number 23CCCR 0154. Case is filed in the state of Texas versus William Kenneth Paults. Let the record reflect that Mr. Paults is present in court with his attorneys. His attorney sitting first chair is Attorney Dustin Galmore.
Good afternoon, everyone.
And sitting second chair is Attorney Haley Simmons. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams, who is sitting first chair.
Good afternoon, and I'll be joined by Sam Masrani.
And Sam Masrani is sitting second chair.
Hey, y'all. Good afternoon.
And for the record, we have Attorney Fred Vernon, who is sitting in the jury box. He's also with the District Attorney's Office. And ladies and gentlemen, the court reporter is Mr. Sebastian Aguilar. He's sitting to my left. And Mr. Aguilar Mr. Sebastian Aguilar will be taking down everything that's being said. So speak up when you're asking questions or when you're answering questions that are asked of you. Our bailiff in this case is Miss Brenda Mosby. She's sitting under the clock over there. And you met Miss Mosby earlier. She was the young lady who called each name for you to come into the courtroom. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but they are just trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer questions in the presence of the panel, just say so and I will ask you to come up to the bench so that we can discuss it more privately. And Mr. Galmore, is 30 minutes enough for you? Or do you need more time?
Yeah, Judge, that should be plenty.
And Mr. Williams, Is 30 minutes enough for you for an hour or you need more time?
No, 30 minutes should be out, Your Honor.
Okay. Okay, so State. Are you ready? State, are you ready? Okay. Hold on a minute. Let me do that. Hold on a minute.
I was waiting. Well.
Okay, ladies and gentlemen of the jury, we're gonna ask that you stand and you're gonna exit the courtroom. And then when the bailiff is ready, she's gonna come out and ask you to come back in. Okay? Both sides, yeah, both doors are open. You can go through either door.
Number one. You're number one. Alfred.
Okay, Ms. Davis, you're gonna come up to the first row. You're gonna take that seat all the way on the end, the first row of chairs. Alfred. You're gonna sit next to Ms. Davis. Ms. Alexander.
Yeah.
You'll sit next to Ms. Alford. Aguilera Perez. You'll sit next to Ms. Alexander. Vonner. You'll sit next to Ms. Aguilera Perez. Aguilera Perez. Ms. Jeffers. You'll sit next to Ms. Vonner. And Mr. Barras. You'll sit next to Ms. Jeffers. Mr. Gutierrez Tavares, you're gonna sit in that first chair right there. Boudreaux, you'll sit next to Mr. Gutierrez Tavares. Ryan Holt, you'll sit next to Mr. Boudreaux. Ms. Carter, you'll sit next to Ms. Ryan Holt. Mr. Arredondo, you'll sit next to Ms. Carter. Mr. Alexander, you'll sit next to Mr. Arredondo. Mr. Downs, you'll sit next to Mr. Alexander. Mr. Hoffmeyer, you're gonna go to that second group of chairs and go walk all the way to the end to that first chair down there. And Mr. Peacock, you'll sit next to Mr. Hoffmeyer. Just follow Mr. Hoffmeyer. Mr. Walton, you'll sit next to Mr. Peacock. Be in the room. Ms. Bienvenue, you'll sit next to Mr. Walton, that's second group of chair. And Mr. Campbell, just follow Ms. Bienvenue and you will sit next to Ms. Bienvenue. Yeah, you're gonna sit next to him. Yes.
Okay.
Yes, Mark, you can sit next to him. Okay. Okay.
I'm missing one.
No, that's the person that was excused.
Oh, that was the next number.
Yes,
Oh, okay.
okay. Yep. Hey, are you ready?
It's ready, Your Honor.
Defense, are you ready?
Just right.
Okay. At this time, Mr. Williams, the panel is yours,
Thank you.
and I'll be keeping time. You get 30 minutes.
That should be ample time. Thank you, Your Honor.
You're welcome.
Justice is a divine concept given to us in the form of law so we can all get along with one another. You know, was a book that was written back in the late 60s, early 70s. I'll tell on myself. The book was everything that I've learned or needed to know I learned in kindergarten. Now, some of us, engineers, some of us have higher degrees, but I submit to you, I place before you that we have responsibilities to one another. And one of those responsibilities to one another is when you're not safe, when we are impaired, we do not put our fellow citizens in harm's way. We have that responsibility to one another. Can we all agree on that? Can we all agree on that? You know, say everything that I needed to know, I learned in kindergarten. We play well with others. When we're wrong, we say, I'm sorry. We don't take things that don't belong to us. And we don't put our friends in danger. Now, this is the state of Texas versus Mr. Holmes. He's represented by able counsel, and this is driving while intoxicated. I submit to you all that during this voir dire, during this time that we're spending with one another, all that I ask, and the oath that you took is that you guys be truthful and honest. Tell us what you like, tell us what you dislike. You may be perfect, you may be, excuse me, perfect for this jury, but you may not be for this jury because of likes and our personal and common experiences, which we've had, where you may not be the right juror in this case. Now, we, Sam and I, we represent the state of Texas. Who is the state of Texas? The state of Texas is made up of us, of the people of the community and the people here within Jefferson County, Texas. Now, one of the elements who we will have to show is that this offense occurred here in Jefferson County, Texas, on a particular day. We submit to you that that particular day is going to be about October 22nd. Once we're talking about speaking the truth, I want you guys to participate. Now, if there's something you think you should tell us, remember when the judge went through those other questions, if there's something you wish to not share with the panel or you feel something personal, it's no problem. We'll make a note of that, and once we complete this, this time of speaking the truth, we'll approach the judge. There are not any right or wrong answers here. We just need to see if you all can be fair to Mr. Paul's in the defense as well as the state. That's all that we ask, is that you use your common experiences to listen and be able to sift through and feed through the evidence. Now, I want to talk about the Sixth Amendment. Part of the reason that is why we're here now. And there's a few important things within the Sixth Amendment, within the Sixth Amendment. It is in all criminal prosecutions, the accused has the right to enjoy a speedy and public trial by an impartial jury of the state and district. That's what you're trying to determine. Can you be fair and can you impartial? He's entitled to that. What is the nature and cause of the accusation against him? We know that it's a driving while intoxicated, that is the offense. And he has the right to confront witnesses against him. Him being Mr. Paul's, he has the right to confront witnesses against him. But I submit something else to y'all. I place before you all that while defense has absolutely no burden whatsoever, they do have the ability to have compulsory process of obtaining witnesses. What does that mean? While defense has no burden, they do have the ability to subpoena witnesses as well. Now, we're going to go through this briefly. Does anyone know Deputy Daniel Sullivan of the Jefferson County Sheriff's Office? He was involved in this case. No hands, there's a no. Does anybody know Deputy Evan Sand? Once again, of the Jefferson County Sheriff's Office. We have Mrs. Memling Altamirano. She is the chief forensic chemist down at the Jefferson County Crime Lab. Does anybody know Mrs. Altamirano? Still no hands. Does anybody know Ms. Rubino Davis? Now, she's a registered nurse. She works here within Jefferson County. Once again, we have no hand. Finally, we believe that Detective Matt Gardner may testify. He was the lead in this case. What I mean by lead, he just put the case together and brought it to the district attorney's office. Now it's time for us to just have a little bit of fun. The DWI law. A person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. Now, I certainly don't want to be offensive to anyone. We all know a Tyrone and a Marcus. We all know, no offense, where's Mr. Boudreaux or Boudreaux and a Thibodeau. And we all know Bubba and the Billy. Through our common experience, we have seen our friends, Marcus, Tyrone, Bubba, Billy, Boudreaux, and Thibodeau, not picking on you, Mr. Boudreaux. We've seen in our common experiences, we have seen people who've been intoxicated. And what does intoxication mean? You all have seen through common experiences, intoxication doesn't have to be me walking drunk, holding on to the porcelain god. It doesn't have to be that. All the state has to show and prove beyond a reasonable doubt each and every element of the offense. Let's talk about that. What does intoxication mean? It means not having the normal use of mental or physical faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more, but we're just focused on the introduction of alcohol because that's what this matter pertains to. Or, not and now, you don't have to be, your normal use does not have to be gone. Your mental or physical faculties by reason of introduction of alcohol. See, you don't have to be drunk on that or having an alcohol concentration of a 0.08 or more. So I ask you, Ms. Davis, would you expect the state to prove both elements of the offense? Not having a normal use, not having a mental or faculty, and having a 0.08 or more? Would you want the state to have to prove both of those? Because we can only prove one or the other, correct? Does anyone disagree with Ms. Davis on that point? Would anyone want the state to show, okay, he lost the normal use, the physical, the normal use or physical or mental capacity, and the 0.08. Would anybody require the state to prove both, or we can show one or the other? Ms. Alexander? Yes, sir. What do you think? Can the state show either one of those two methods? And can you return? Go ahead.
I think, either one, because the law states it's defined by the law, the same from the word on is here.
And the word or. Now, we know or is disjunctive, and let me go on and say this, you all. We have several teachers on this panel. Let me, on behalf of not only Sam, but also on behalf of Defense Council, thank you so very much, you all, for being here. Y'all do a yeoman's task. So I did want to thank you, Ms. Davis. Thank you, Ms. Alexander. Thank you, Ms. Vonner. Thank you, Ms. Rhino. Thank you. As we continue, obviously, the more a person drinks, the more in which they imbibe alcohol. The more that they do, the more intoxicated that they become. I submit to you that opposed to being the stumbling drunk on the far end, you may have Tyrone, Bubba, and Boudreaux. They may look fine, but Tyrone, Bubba, and Boudreaux. Okay, you know what? I gotta switch that to Thibodeau, okay? Yeah, I'm switching it to Thibodeau. Okay, Tyrone, Bubba, and Thibodeau go to work, getting out from the crimes or whatever. They envy alcohol. They drink alcohol. You may look at them, they may seem fine. They think, oh, normal, physical and everything is, everything is normal. But then their blood comes back above the legal limit of a 0.08. Conversely, Marcus, Billy, and now Boudreaux may be below that 0.08, but then too, since they don't normally drink like the others, okay? But they've lost the physical, the mental capacity. How do we know that? Maybe they talking, maybe they are a happy intoxicant, maybe they are a mean intoxicant. Judging from the slur of the speech, judging from the manner in which they move. This is all from our common experiences. Physical faculties, what does it mean to, the ability, to balance, so visit the ability to balance, the ability, to walk, the ability, let me see your license and let me see your registration and dexterity. Walking in a straight line, not stumbling. The mental faculties, can one follow directions? I submit to you that without being way out to the point of me walking, stumbling, drunk, a person may not be able to follow. They may look fine, they may look seen, they can't follow directions. The judgment which was used was that would have been reasonable. The ability to concentrate and forming, of course, complete sentences. Now, we believe that the evidence is going to show in this case that although on the left-hand side of the screen, we have what we call direct evidence. What I mean by direct evidence. You see something happen yourself. None of us was there, so none of us saw something that had happened ourselves. But I submit to you, like what happened last Friday here in beautiful Southeast Texas, when the rain started coming, you could be sitting in here. I know it was dry when I walked outside, when I came in this morning. You can know through circumstantial or indirect evidence that it had rained. We applied the same analogy, direct evidence and circumstantial evidence, to the facts which will be presented in this matter. So now, since I've been picking on you, Mr. Boudreaux and your buddy Thibodeau, would you expect anything more from the state, or can you treat direct evidence and circumstantial evidence? Would you?
Say yes, and treat it the same as certain sentence.
Because if you, this is my dog Dumpling, and when I left this morning, we have no other dogs. We don't have like a dog door. And this, ladies and gentlemen, is going to lead into a brief discussion on reasonable doubt. How I'm doing on time, Judge?
You have 15 more minutes.
We're not going to do that long. But I have some questions for you all. Okay, Dumpling, I left him at home this morning. Okay, I don't know how Dumpling got out the cage, but I get home and Dumpling tore up the cushions on the couch, and you walk in, and the dog goes, "Whoa, whoa," and looking sad and pitiful. If we have pets, we know how a dog can look sad and pitiful. You come home, you see this. Now, you didn't see Dumpling tear up the couch cushion, did you? But can you conclude, beyond a reasonable doubt, again, that there's no other pets in the house, there's no doggy door and stuff? Can you conclude, although you did not see Dumpling, can you conclude beyond a reasonable doubt, Mr. Downs, that Dumpling tore up
I think you could include that.
Mr. Alexander, could you conclude, that dumping and toward the couch and treat circumstantial evidence and direct evidence the same? Can you do that? Mr. Arredondo, looking at both, can you treat direct and circumstantial evidence the same? Given the example, which I had done to us before, or would you need more? Thank you. Mrs. Carter? Would you be able to conclude and treat direct and circumstantial evidence the same?
Yes.
Thank you. Ms. Rhino?
Yes.
If you don't mind, what do you teach?
I'm not a teacher.
You're in administration, you would be on the business side. Thank you. We're going through a lot of turmoil. I'm not skipping over you, Mr. Boudreaux, but we had our conversation a little bit earlier. Mr. Gutierrez Tavares. Can you treat direct evidence and circumstantial evidence the same?
Yes.
Now, let me ask you this, Mr. Tavares.
Yes.
Barras?
Bears.
Mr. Bears.
Yes.
Should the state prove each and every element of this offense beyond a reasonable doubt through circumstantial evidence, would you require the state to present you with anything more along the lines of direct evidence?
Yes. I would,
Please continue.
but like I'm seeing up there pictures don't lie.
Ms. Jeffries? Is it Jeffries?
Yes.
Yes, ma'am, Ms. Jeffries. Okay, having not seen down, but in this case, if the state, if we had to treat direct and circumstantial evidence the same, okay? And if the state proved each and every element of the offense that it occurred on a particular day in Jefferson County, Texas, while he was either impaired or over 0.08 through circumstantial evidence, would you hold the state to a higher standard than wanting direct evidence?
I don't really know. I think it's all circumstantial for me, which evidence we're talking about.
Yes, ma'am.
Is it, you know, is what alcohol level been tested? Was it done right? Stuff like that would make a difference for me.
Okay, thank you once again for your candor. Now, does anyone else agree with Ms. Jeffers? Jeffers, I'm sorry. You do. Now, are you saying now, Ms. Alexander, you think that you would need more than circumstantial evidence if the states to show? If the states to prove each element of the offense beyond a reasonable doubt, would you need more?
I guess what I'm saying, I don't think the conscience can make that judgment without knowing more facts and something.
Fair enough, and should you be able to get on a jury, we can't go into a deeper dive into the facts of the case, should you be chosen, but that's why I appreciate you guys being candid, you know, and sharing how you feel about it. By the way, what did you teach?
Mathematics.
Sixth grade?
No,
Okay.
middle school, high school.
Oh, okay, well, thank you very much. Okay, personal priority right now. How long have you been in the district, you don't mind? A bit?
I've been
A bit?
teaching for 31 years.
I was just
25, yeah.
I feel like once you said math, I had wanted to be an astronaut, but I had a wonderful teacher, Mr. Stadier Love. And after taking calculus with Miss Love, the deal was, Miss Love couldn't flunk us. She said that I will flunk you little people. And I'll never forget, after placing out of the AP calculus, it was a different time for like the teaching. But in that AP class, I was thoroughly broken of the habit the thought that one day I'll be an astronaut. But Miss Love, she encouraged me to see you still look like that. But thank you once again for the invitation. I have to touch base with you, Ms. Aguilera Perez. Can you treat direct and circumstantial evidence, not knowing more about the case, but can you treat those two things the same? Now, let me ask you all this, ladies and gentlemen, one more, Miss Alfred. To finish the list, can we realize that Mr. Paulson, of course, he's not Dublin. I mean, this is an example of circumstantial evidence. Will you be able to hold the state to its burden, even if it is to show by circumstantial evidence each and every element of the offense beyond a reasonable doubt, or would you need more evidence?
So I think it would, depend like they were saying, kind of depend on what that may was.
Ms. Aguilera Perez, we expect this trial, feel free to correct me, Mr. Galvin, we expect this trial to probably last until Thursday, we'll have tomorrow afternoon, Wednesday afternoon, maybe we'll conclude on Thursday. I saw that you have two minor children, correct? Will you be able to, can you be here? For like today's sort of trying if we go on to Thursday? Is there anyone, for any reason, should this matter go into Thursday to where they can be here? Yes, sir, that is Mr. Arredondo? Yes, sir. Do you want to come up when we get done?
So I take care of my niece by 3:30 to like 8. So I'm not sure if that's like around the time they might have it.
We'll make a note of it, okay? The court is not going to give you any definitions of what is beyond a reasonable doubt. For what I submit to you, it is the highest burden that we have in the law, but you know what? We welcome that burden. We want that burden. It's up to us to prove each and every element of the offense beyond a reasonable doubt. The reason why I spent time on direct and circumstantial evidence, this is the manner in which we prove offenses beyond a reasonable doubt. Now, he doesn't have to prove anything, not at all. And at no time will the state even like, of course, intimate that. The burden is on the state, and we welcome that burden. You know, when we had talked about Thibodeau earlier, we talked about Bubba, and we talked about Tyrone. If you were chosen to sit in that box and be on the jury, you do not leave your common sense when you sit there, nor when you go back there to deliberate. Our common experiences is the filter in which we use to interpret the evidence in light of the law. Our common sense and common experiences is the filter in which we use to view the facts and interpret the law. The court will give you the law in this case. The fact, should you be chosen, you all are determine the facts. And our obligation is to prove the elements, the facts, beyond a reasonable doubt. Now, it's not all doubt. Come on, work with me here. Now, it's not all doubt. It's what's reasonable, right? True, would it be reasonable, anyone, to think that, okay, Mr. Paulson Davis could have came down, took over his car, took over, I submit to you all, that that's just not reasonable. You just actually use your common sense in the filter on that. Here's a time if you guys have any questions of me, I would gladly entertain any questions. Sure.
How much longer do we have in?
Say it one more time.
How much longer do we have in? I kind of have to go a little bit.
Yeah, I got you.
Is there a little that this will be 2:30 and it's already an hour past that?
Yeah.
Want to see how long we got in?
At least
We're gonna complete board out.
Can we?
Maybe we should
Judge.
approach. I don't know, search. Yes, pick the niece.
Right.
I don't.
I will conclude with the following. May it please the court?
Yes, you may proceed.
Can any member of the array think of any reason that they will not be able to serve sedated children in this manner? I see, no hands. Thank you for your time and your attention.
Okay, Miss, okay,
Yeah, it works.
you need to.
All right, sounds good. Usually does. Good afternoon, everyone. How's it going, buddy? Everyone, looks pretty excited to be here. All right, who's excited to be here? Is anyone excited to be here? Really? No one's excited to be here? All right, there we go. I mean, I'm kind of excited, right? Number 3, 6, and 7. Let me write them down. 3, 6, and 7. Who else? Who's excited to be here? Every time I get jury duty, I'm excited. Number 1, I'm on vacation because they can't make me work if I'm on jury duty, right? But I want to see the experience, and I'm probably never gonna get that chance. As soon as they see me out there, you know, I'm out. Okay, so let me just go through the panel for a second. I want to ask a couple of questions. Number 1, a lot of BISD school employees in here. BISD employees in here. Does any BISD employee know another BISD employee in here, right? No. Does anyone know another person on the panel? Maybe, I see a hand or two, okay. 7, 14, 15, and 19? You are 18? Okay. So how do y'all know each other?
I used to work with his wife.
Okay. Okay. That's what you raised your hand too. Okay. Nothing about that would interfere with your ability to be a juror, right? Okay. Anyone else know anyone in the courtroom? I gotta figure out the numbers. Miss, oh, shoot sheet here. Too many cheat sheets here. Miss Carter. All right, Miss Carter, who do you know? Okay, how do you know Judge?
Church. Attorney sororities, other social events.
Okay. Would anything about your relationship with the judge affect your ability to be fair and impartial in this case, do you think? Okay. Is anyone else in the jury panel know anyone else in the courtroom? All right, good. Get some of those things out of the way. Let's see, Miss Davis. You have a postgraduate degree?
Yeah,
Okay, what's your graduate degree in?
biomedical science.
Well, see, I saw that. So you're a math teacher?
Yes.
6th grade? Okay. But I saw your skills was biomedical research. So is that kind of like a hobby or something that you're looking to get more into in the future?
Honestly, I wanted to be a researcher since I was small. So
Yeah.
I did that dream and then math teacher.
Become a math teacher? All right, well, that's interesting. Let's see. Miss Alexander. Post-grad, what degree you got?
Doctorate degree.
In a doctorate degree in what?
Teacher leadership.
Teacher leadership, okay. Did you get that at Lamar?
No, sir, Walton University.
Walton University, I don't know where that is, where's that?
That's, their home base is Minnesota.
Okay, interesting. I'll refer you to as doctor. Let's see here. And then I think you had a daughter that's a law enforcement, she was a federal prison, worked at a federal prison, correctional officer? Okay. Okay. Is that local or out of the area?
Here.
Here? All right, okay, let me ask you a question. Sometimes I have it up there, I don't have it up there today, so I apologize. The question is, are misfortunes typically thrust upon a person? Or are those misfortunes typically from mistakes that they have made in their life? Just think about that for a second. Misfortunes typically are thrust upon people, or are they typically from the mistakes that we've made in our life? Okay, so think about that question. And the way I want you to answer it is number one would be it's thrust upon people. And number 7 would be it's all based on their own mistakes in life. And obviously somewhere some people might be in the middle. Yeah. But a scale of 1 to 7. Does everyone understand it? Okay, all right. I'll just go through and ask each juror to give me your number if you don't mind, on a scale of 1 to 7. So juror number 1, Miss Carter, right? Miss Carter? I'm sorry, Miss Davis. What number would you say?
Tell me the scale one more time.
Okay, so on the scale of 1 to 7, a 1 would be that you believe misfortunes in people's lives are chance and are just thrust upon them. And on a 7 would be that those misfortunes are always as a result of the mistakes that they made in their life.
I would say a 5.
A 5, okay. All right, does everybody understand the scale? All right, so a 5 would mean that you believe it's a little more leaning towards the mistakes that they've made in their life.
You can open the door for things to happen.
Okay, all right. Let's see. Okay, juror number 2. 5. So you agree with her thing? Okay, juror number 3.
4.
4, and juror number 4.
Say 5.
5, juror number 5. 4, juror number 6. 4, juror number 7. 4. Now, I want everyone to know, it is okay to not be a 4 or a 5. Juror number 8.
3.
A 3, there we go. Juror number 9. 5. A 5. 10.
5 as well.
5 as well. Juror 11.
6.
6. I like it. There you go. You don't have to do 4 or 5. We're gonna skip. We're skipping. Oh yeah, Mr. Redondo just left. Okay. Mr. Alexander. 4. 4. Mr. Downs. 4. 4. Mr. Hoffauer.
Say 6.
6. Mr. Hoffauer. Do you have a son named Kobe Hoffauer?
Probably no, I don't.
No. Do you know him?
Don't think so, no.
Okay. All right. Lawyer around Mr. Hoffauer. Miss Peacock.
3.
I'm sorry, Mr. Peacock. A 3. All right. Mr. Watt.
4.
4. Miss Bienvenu.
Hi.
Did I say that right, Bienvenu?
Close enough.
Okay. Does it sound better if I just like say it real fast? And
Yeah, I know you're talking.
what number did you say? I'm sorry.
5.
5. And Mr. Campbell?
I say 3.5.
You can. I like that. I like that. And then Miss Lee. Miss
She-
Scott. Miss Lee Scott. Okay, sounds good. All right, let's move on to something else. Let's see. Miss Perez? You served on a criminal jury one time? Okay, did y'all reach got into the verdict, did y'all assess a punishment? Did the judge assess a punishment, do you know? You don't remember who gave a punishment? Say that again? It's not guilty, okay, so there's no punishment. Okay, what court was that in? You remember? A felony or misdemeanor, do you remember that?
It was a murder.
Murder, okay, that's definitely felony. That's bad as it gets right there. Okay, let's see here. Ms. Bonner, what school do you work at? Marshall, okay, I meant to ask you what school you work at. Smith.
Each McCarthy.
Peach, all right. Okay, Ms. Jeffers, did you go to, Hampshire for that? Okay. Where, you know, hospital, where, you know, what hospital you born at? You know what hospital you were born at, Baptist St. Elizabeth or some other city?
I was born in, Arkansas.
Oh, okay. Well, thought maybe if you were born here, I was born the day before you, right here in Beaumont. So,
Since I was 4.
one day apart. All right, let's see here. A Windstream. What is that?
It's a telecommunications, it's for my husband. I'm still home office.
Okay. How many kids are? How many kids?
21 and 18. But I also take care of my father. Oh.
You had a criminal jury, right?
I'm
You
sorry.
had a jury? You were on a jury criminal?
I've been
jury?
on quite a few.
Quite a few, okay. Y'all had both verdicts, guilty and not guilty?
Well, one was, to be registered as a repeat offender, sex offender.
Okay.
That was one, and, I was on a pretty big sex offender case that was guilty. And then one for failure to register as a sex offender, and that was guilty.
Okay. All right, let's see here. Let's have another question. This question is, police should be able to stop and question suspicious people and detain them to determine if they're up to something illegal. Okay, think about that. Police should be able to stop and question suspicious people to determine if they are up to something illegal. What do you think about that, Ms. Carter?
That's my little turn.
I was looking over here. I keep on calling you Miss Carter for some reason. I have that just ingrained. Were you number one originally? Is that what it was?
Yes.
Okay,
Yeah, no.
that's what it was. I keep guessing. Okay, well, how about you then? Let's go to you. What do you think about that?
It depends on what the reason is, what suspicious is.
Yeah.
The definition is just.
All right, what do you think about that, Mr. Alexander?
Kind of loaded question.
Kind of loaded question. Tell me what you mean.
Yeah, who's determined the suspicion?
Take the word suspicious out. Police should be able to stop and question people to determine if they're up to something illegal. What do you think about that, Mr. Downs?
No, they should.
Sorry?
They should not.
Should not.
Stop.
Okay.
For just, for kids.
Not for kids.
Right. Like he's guilty of reasonable suspicion of the ground.
And that's the legal standard, right? What about a hunch? Now, what do you think, Mr. Hoffman? What do you think? You think police should be able to question people based on hunches?
No, I'm not comfortable with that.
No. Who thinks police should be able to stop and question people to determine if they're doing something wrong? And if you're kind of on the fence, just tell me what you think. Anybody want to talk about it? I see you're kind of grimacing there a little bit there, Mr. Barasa.
I want to see, you see something, say something.
Okay, if you see something, say something. I like that. Right. What do you think, Mr. Gutierrez? Where do you kind of draw the line on when the police should be able to just talk to people, make them talk to them versus not?
Personally, I think we all live in the same society, right? So if we are technically all working together, we should at least have some sort of trust in the people that are just living their lives from day to day. So, no, I don't think so. I think they need to probable cause, there needs to be something that really you see something they swerved in, or they have like, you can see guns in the back, something like that. But in general, they have to be at least 99% sure.
What about you, Mr. Grigio?
I agree with what he said.
What about you, Miss Reinhold?
I don't think that we should be able to pull them to the wrong time, sure. It's because they want to find something.
Okay. That may be a good segue into this next question. And that's what that is right there. There is this law in the Texas Code of Criminal Procedure, what it says is that no evidence obtained by an officer or other person in violation of the law, basically, of Texas or the United States laws, shall be admitted in evidence against the accused on the trial of any criminal case. So what that's saying is if evidence is collected illegally, right? A rule was broken in the collection of the evidence, right? The police basically did something they weren't supposed to do, right? Maybe if you're talking about scientific evidence, the protocols were not followed, right? That's the rule. I mean, that's the law in Texas. Ms. Davis. I did get it right this time. I like to start back on number one, and I kept beating you on it. So, Ms. Davis, what do you think about a law that said if the police collect evidence the wrong way, that you're not supposed to use that? What do you think?
I do think that's a good act. Even though they may have uncovered something that could be something of importance, but the way that it was collected, you have to think about the motive. Were they collecting that to prove something, honestly, or just to create something?
What about, Ms. Alfred? Somehow you've avoided some questions here today. What do you think?
Yeah, I think the person who collected the evidence, they know the law too, so they should have followed the law.
They should follow the law.
If somebody else gets consequences for not doing mine, shouldn't they?
Well, let me give you an example here. Let's say, in a marijuana case, that the police, they do something wrong in the collection of evidence, right? And it leads to the discovery of this marijuana in the trunk of a car, okay? And you, as a juror, believe that the evidence was collected improperly, whatever, all right? Can you ignore that marijuana that was found and find the person not guilty since if that's the only evidence available to support the element? I mean, get results and not guilty, you would be able to follow that law? Yeah, what about back to you, Ms. Davis, what do you think?
I do.
Yeah. Well, let me ask you, Ms. Davis, let's say that bag of marijuana was a dead body. Okay, we're talking about a murder case, right? What did you say?
Now you're gonna start digging deep.
Right? So, guess what? The law does not change, right? Nothing changes about that. Everything stays exactly the same. So, Ms. Davis, do you think in that scenario that you would say, hey, I can ignore that evidence even if it results finding someone not guilty of a crime that I believe they committed?
I do. I would think there would be a better way to use it. So if it's not through that segue, which it wasn't correct, there should be another way to come for that evidence to prove whatever's wrong.
There should be, right? In a perfect world. And even though we may have the best legal system in the world, it's not perfect, is it? No. Has anyone ever heard of someone getting death penalty when they were innocent? Can you imagine that? Like, one thing to go to prison for the rest of your life, right? But can you imagine for something you didn't even do? You really just didn't even, you're strong person. Can you imagine? So criminal justice in America is not perfect, right? So what do you think, Miss Alexander? Do you think we're a scenario where we're talking about a murder case or, a kidnapping case that you would be able to say, hey, they don't follow the rules correctly? Sometimes a guilty person has to go free.
Sometimes guilty people do go free, but I would want to know, if I can't say or there's no evidence presented that the person driving the car has something to do with the body. I mean, I just would have to know what is going on. If it's me and I'm driving a car and some kind of way somebody got in my car and did something, I have no knowledge of it. I'm sure it's like to leaving your bag in the airport. Somebody put something in you don't know. And so I would just have to know.
The facts matter.
Not to be prejudiced towards her.
The facts matter, right?
Yeah.
Make sure one thing. We're definitely not talking about it like an unknowing situation, okay? We're not, the point I'm trying to make is that everything is known, all right? The facts are out there. But you made the determination of a juror that you are supposed to ignore evidence because of a finding you made that the rules were not followed. The question is, yes, it's easy to do that in a marijuana case, right? Who cares? Is it easy to do in a murder case or in a sexual assault case? Is it easy to do there? No, it's not easy, right? It's not. But can each and every one of you raise your hand and say, I can do it in any kind of case? It does not matter the severity, or does the severity matter? Not the facts, the severity. Does the severity matter? You know, what do you think? We'll go someone named Ms. Perez. What do you think? You think the severity matters? To you, just to you. It doesn't matter for everyone. I mean, your opinion doesn't matter to you.
It does, but it would depend on the case. Once, he was with all evidence and the information, I think it would. But that's what.
So it sounds like you're saying is the severity doesn't matter, but then when you say it depends on the facts of the case, it sounds like you're saying that you'd be able to follow that rule no matter what.
I would try.
You'll try.
I would
Okay.
definitely try.
That's what I'm talking about. Does everyone understand what we're talking about now? That's really the heart of this. Miss Bonner, what do you think? Does the severity matter or does it not matter? Could you follow that rule no matter what?
Yes, for instance, that interesting that, the parties have thoroughly assessed the case regardless of the severity.
So in a situation, no matter how serious the case, you could follow that rule, even if it meant that you might have to find someone not guilty.
I'm told to go based on what I'm providing. So if we're looking at what the law says, I have to go with the law says, and I'm required to do.
Okay, all right. We'll jump around. Well, actually, I don't want to jump around. I'm going to ask you, Mr. Barras, because we're making headline a minute ago. It's a murder case.
Yes.
And you ignore that evidence. Could you find someone not guilty even though you believe they did it just because you believe the police broke the rules? In a murder case, would you do that?
Yeah, I think I could.
Could everyone do that? Could someone not do that in a murder case? Too serious, not gonna let that person go. Okay, Mr. Gutierrez. Tell me what you think.
Just like you said, the severity, and sometimes like some laws outweigh the other, in my opinion. So like if something were to happen like that, it's your job to find out the truth, because it's no longer just you, it's everybody that's involved with it.
So you could at least see a scenario where it could become such a severe consequence of letting a person go that might be a decision you could no longer make. You could no longer follow it at some point.
Yeah.
At some point.
Yes.
Okay. Without putting a line at some point. Who agrees with him? That at some point, I probably couldn't follow that rule. Anyone. You were nodding your head, and that's Miss Carter, right, Miss Carter?
Yes.
Okay. Tell me what you think.
Again, severity, will impact, there could be other things going on and being said that could impact. A blind rule, the law, I understand that, but.
But you might not be able to follow it if this
There
consequence
could
is
be
too great.
situations, things occurring that just somehow says you need to think, or there are other questions that are not being answered, not being asked.
Anyone else agree with Mr. Gutierrez or Ms. Carter? Anyone else? Okay. Let's see here. Let me go back to this. Mr. Peacock. I want to say, didn't you have an interesting degree? What's your degree in?
I have my MBA in analytics.
Okay, did you say where you went?
Lamar.
Okay. I have finance and I have a bachelor's in finance. And then you said but you stayed at Lamar, got your master's? Interesting. And so did you use that master's degree at Do Good? Is it Do Good, right?
Yes.
Yeah.
Not really.
I was supposed to go over to the bank too. I didn't know, but city clerk. Super. All right, looking at the wrong one first, okay, and Mr. Alexander, you've got a, wait, was that on the right one, Mr. Alexander? No, sorry, it's, back to Mr. Alexander, Miss Alexander, you have a, cousin and, you have a nephew and, as a constable? Oh, look at Timothy Alexander, I'm sorry, there's two Alexanders, there you go. You have a, family member as a constable?
Yes.
In Mississippi, okay, that was my next question, was that local or not? Mr. Downs?
Yes,
You work for HB Hill?
I do,
How long you been there?
about 6 months.
Okay.
I retired from the city
City of Beaumont,
26 years.
26 years, what'd you do for the city of Beaumont?
Worked in IT for 23 years and then I was over water customer service
Yeah.
for about 3 years.
Okay. Good buddy Kenny, over there in water, right? Kenny Johnson?
I'm customer service side, so.
Okay, so you're not on that side.
No, it's Max Harrison.
You had a civil trial,
I did.
and what kind of case was that?
It was, medical malpractice.
Did you file for the plaintiff or defendant, you know?
The defendant.
The defendant.
Yes.
Um,
Years.
and then, Mr. Hoppower, you had a civil, you had a civil and criminal trial? Mr. Hoppower?
Yes.
Okay. What kind of, that case was your criminal trial?
It was I think it was manslaughter. But they decided to let the judge
Do the punishment?
do the punishment.
In the middle of the trial?
In the middle of trial, yes,
That was on a criminal trial?
yes.
What was your civil trial?
It was just a small claims court, I can't remember what it was.
Okay. Yes. Let's see here, Mr. Watton, you had put something on there about criminal trial experience. I don't know if that's a witness or what, is that something you wanna talk about right here, or talk about it later, or?
I'm putting that on.
I just don't know what it is, oh, it just says criminal trial experience.
I mean, I've been to cases before, I've never been to.
Can I ask you questions about that now, or you wanna ask them afterwards, or? Cause there's an opportunity after this, we can talk to people more in detail, and so I'm just wondering where.
I mean, it's not experience, it's just, I've been involved with the jury service before.
You've been a juror before?
No.
No,
Never, just been involved with it, that's all I meant by that.
okay, okay. Let's see here. Miss Benview, you're retired? No, your spouse is retired.
Well, I can't get.
Where is he retired from? And you had a criminal jury trial before?
Yes.
Ms. Gilmore, you have 3 minutes.
Okay, thank you. What, do you, did y'all give a punishment out in that case?
Yes.
What kind of case was it?
Right.
Mr. Campbell, you retired?
Yes,
Yeah, what'd you retire from?
the console operator at Montego Refinery for
Okay. Civil trial?
civil trial 2 years ago.
What kind of case?
It was an accident,
Okay.
vehicular accident.
Where do you like to play that?
Anywhere I can.
Anywhere you can. Me too, me too. I hear Brentwood's doing really good now, but I haven't played it just yet.
Nah,
No, it never isn't.
About 2 minutes.
You had a brother that was a former police officer, or was it a police officer?
former,
Local?
no, Franklin, Louisiana.
All right, Miss Lee's gone. Okay, so the only other question I actually had was, I'll give you an example. A long time ago, I had my car broken into, and, I was not very happy about it, mainly because the window's expensive. Easy, you steal something silly, the window's broken. had I gotten picked on jury duty for the next year, I probably been a little better, okay, to be honest with you. I was not gonna be a good juror for a car theft case. Is there anyone here that's not a good juror for DWI? You know, maybe you had a loved one that was involved in a DWI or a DWI wreck, alcoholism, anything. Sometimes we have, you know, specific questions, and I'm just gonna ask the general. Any reason why DWI might not be the right trial? Anything? Okay. Anything else someone thinks we should know? We just didn't ask?
Yeah, 1 minute.
Talking private? Okay, all right. Thanks, everybody. Look forward to presenting the case to you.
Okay. Okay, ladies and gentlemen, at this time, we're going to ask that you go out into the hallway. You can use either one of the doors. We may call some of you back in for some follow-up questions. Everyone, please stand as the jury exits the jury room. You may be seated. Jefferson County Court, law number 2 is back in session. The court is in session and calls number 23 CCCR 0154. Case is styled the state of Texas versus William Kenneth Pulse. That the record reflect that Mr. Pulse is present in court with his attorneys, Attorney Dustin Galmore and Attorney Haley Simmons. Let the record also reflect that the state is present with Assistant Criminal District Attorney, Attorney Cornelius Williams, and Attorney Samuel Masradian. Let the record also reflect that the panel is now present and seated in the courtroom. At this time, ladies and gentlemen, our court coordinator, Ms. Glenda Segura, is going to call some names. If your name is called, please go up and have a seat in the jury box. And before you're seated, there are some badges that are on the countertop. You can take one badge and pin it to your clothing. At this time, Ms. Segura, would you please go forward?
Jakira Davis,
Jakira Davis,
Ashley Melford, Melinda Jeffers, James Gutierrez Tavares, Brian Boudreaux, Timothy Alexander, Isaiah Peacock.
It's like the NBA track.
Ready for time.
Okay, ladies and gentlemen of the jury, I must administer to you the second of the 2 oaths that I previously mentioned. And I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, I do. Do each of you solemnly swear that in the case of the state of Texas versus William Kenneth Pulse, you will a true verdict render according to the law and the evidence, so help you God? Please say I do. Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions, interpreting them and how they apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will properly make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can hear the discussion on the parental law. The reason for this, as I told you earlier, You are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him. And the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument until you retire to deliberate. Do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper, on social media, or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, you will be allowed to take those badges home with you. Please wear those badges at all times because those badges will identify you as a juror in this case. Ladies and gentlemen of the panel, those of you who were not selected to serve as a juror in this case, first of all, I would like to thank you for taking time out from your busy schedules to be here this afternoon. I know that some of you may be disappointed because you were not selected. Some of you might even think that, you know what, I came up here to serve as a juror in this case and I was not selected. I wasted my time. Well, ladies and gentlemen, you did not waste your time. And the reason why I say that is because, as I mentioned to you earlier, this morning we had 3 dockets. We had over 50 cases that we had to deal with this morning. Some of those cases were on our jury trial docket. And some of those cases, a lot of those cases were disposed of this morning before you even got here. And I always say that, you know, sometimes what people don't understand is that the case that when it comes up for trial, the case was filed and the person who has been charged got an attorney to represent them, and the state and the attorney, the state made an offer to settle the case. And now we're at this point, but before we get to this point, sometimes people say, you know what, that offer, the state made an offer, I'm going to reject that offer because I believe one or two things is going to happen. One, the jury's not going to show up, or maybe the witness is not going to show up. But on days like today when jurors show up and witnesses show up, it's not uncommon for some people to say, you know what, I think that offer that the state gave me a few months ago looks pretty good right now. And so in essence, the case usually get disposed of. And so I say that to say this morning, cases were disposed of because of people like you who took time out from your busy schedules to come here this afternoon. We cannot move jury trial. We cannot have a jury trial without a jury. And so, again, ladies and gentlemen, on behalf of the citizens of Jefferson County, on behalf of the staff here in County Court at Law Number 2, I'd like to thank you for taking time out from your busy schedules to help us move cases off of the docket. Now, I know that some of you, when you came here this afternoon, you was looking for County Court at Law Number 2, you probably looked over the door and you said, oh, this is County Court at Law Number 2. This is Judge Holmes Court because you saw my name over the top. Well, this is not Judge Holmes Court. This court is for the citizens of Jefferson County. I'm only a humble public servant serving the citizens of Jefferson County. I've said that to say this. Anytime that you're in the area of County Court at Law Number 2, you can have a seat in this courtroom in that area that you're sitting in, okay? And you can have a seat in your courtroom. We call that area the peanut gallery. But you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and just see what goes on. And I know you can, I'm sure you'll find it very interesting. Now, before you leave, our bailiff is going to give you some letters. If you'd like to drop us a line, please feel free to do so. But before you leave, I usually give everyone a handshake. We still have COVID in our community. However, I'm going to give you what I call an air handshake. So on behalf of citizens of Jefferson County, County Court at Law Number 2, thanks for coming down here today. And you are excused if you need, well, the district clerk's office is closed at this time. If you need anything, just let the bailiff know. We'll have our court coordinator if y'all need letters or anything. So each and every one of you have a blessed day.
If you need excuse, just stay in here and I'll come back.
All right, see you later, Ms. Carter.
Thank you.
All right.
You start to see excuse letters now, okay? Okay. Like I need excuse letters. Okay, I need that. That's it's not.
They can, she's probably gonna, I don't know if she's gonna come in here and do those letters. Okay, state, are we planning on starting testimony on tomorrow?
Yes, yeah.
Okay, ladies and gentlemen, we'll be in recess until tomorrow. I'll just give you a general idea of what to expect when you come back tomorrow. Tomorrow, what we'll do, first thing we'll do is present the information. The state is going to read the charges. The defendant is going to enter his plea to that charge. And then from there, we'll have opening statements that by the state, and if the defense would like to have theirs, or they can reserve it. And then after opening statements, the state will call their first witness. They'll present their case. Okay? So that's what you can expect on tomorrow. So at this time, ladies and gentlemen, you are excused. Make sure that you have your badges on when you come to the court.
Alexander.
All right? And when you come back to the courthouse on tomorrow, you're going to have a seat outside the courtroom. All right? So at this time, you're excused for the evening. Every one of you, yes. We're going to be back at 1:30. 1:30. Thanks for reminding me. Okay. All right, everyone, please stand as the jury exit the courtroom. Okay, the court will be in recess.
Yes.